Good morning, everyone. If you'd find your seats, we're about to begin. All right, good morning. Welcome to, I'm Brian Pomper. I'm the Executive Director of the Innovation Alliance. I apologize for my husky voice. I am on the upswing getting over the flu. I promise this is not the coronavirus, just a typical flu. Welcome to our mostly annual Inventing America conference. We've had this conference now almost every year, I think, for the last 10 years or so, and mostly in conjunction with the same co-sponsors that we have today. So let me thank those in alphabetical order. The Alliance of U.S. Startups and Inventors for Jobs, or USIJ, the Association of American Universities, the Association of Public and Land Grant Universities, the Biotechnology Innovation Organization, the Medical Device Manufacturers Association, the National Venture Capital Association, Pharmaceutical Research and Manufacturers Association, and new this year, U.S. Inventor. Thanks to all of you for co-sponsoring this conference. It's appropriate that we are here today on National Inventors Day to talk about the important issues facing the patent system and the future of the United States. America was made strong by the incredible hard work and ingenuity of its people, and by a policy environment that appropriately rewarded innovative risk takers. I know I'm not alone in this room in believing that policy environment to be under extraordinary stress. Many believe we have witnessed an erosion in the patent system in the last 15 years, from court decisions, changes in the law, and a relentless and ongoing public relations campaign against the patent system by those who stand to benefit by weakening it. This is happening at a time that the United States faces a real challenge to its economic future by a large competitor focused especially on dominating the innovation economy of the future. Perhaps every generation believes that it faces unique challenges, and perhaps that is true. But at this particular moment in American history, it certainly feels to me that we face a challenge to U.S. economic preeminence like we have never faced before. I don't mean to sound melodramatic, but I believe our very economic model is at stake. We have to fight to make sure we have the right policies to meet this challenge. And I believe a robust patent system that rewards innovators, empowers upstarts to challenge incumbents, and allows patent holders to hold their far more powerful rivals accountable for their actions is a key to meeting that challenge. Why do I believe all this? Well, let's hear from our speakers today and see what they have to say, and you can decide whether you agree. And hopefully we can work together to make the environment such that we can compete in the future. We have a great set of speakers who will tease out these themes. Preeminent experts in their fields, people who have lived at the pointy end of the patent system, senior public officials. And special thanks to USPTO Director Andrei Iancu, who is making at least his second and perhaps third appearance at this conference. He's eager to answer your questions, so please start thinking about a question you would like to ask him when he speaks during lunch. I look forward to hearing what everyone has to say. Thank you for coming. Let me invite the first panel up.
Good morning, everybody. I'm Lisa Jorgensen. I'm the Executive Director at AIPLA. I'm going to moderate the panel this morning of our distinguished guests. What I'd like to do first is just introduce you to each of them and the topic that we would like to share with you with the questions that we'll ask. I think it would be easier if we wait till we get towards the end for questions. But if you have something that's really burning that you'd like to ask them on the subject that they're talking about, please go ahead. Let me start with Professor Adam Mossoff. Professor Mossoff is a law professor at George Mason University, where he researches and teaches property law and patent law. His research has been relied on by the Supreme Court, the Federal Circuit, and federal agencies, and he has been invited numerous times to testify before Congress. Today, we'll start a subject with him in a minute on efficient infringement. Next to Professor Mossoff is Josh Malone, an inventor and entrepreneur. Josh Malone quit his corporate job back in 2006 to take his shot at the inventor's dream. 8 years later, savings depleted and kids' college unfunded, he took one last swing before trudging back to the corporate world. He hit a home run with an invention called bunch of balloons, which many of you may know. His solution to the 63-year-old problem of filling and sealing water balloons instantly became the #1 selling summer toy. Now, I have a number of other comments I can make, but I'm going to let Josh tell his story when we get to that. At the end is Matthew Mrose. He's the Director, Enterprise Technology Transfer at the State University of New York Research Foundation, so SUNY RF. In this capacity, Matthew leads the development, implementation, and management of enterprise-wide technology, business solutions, and programs that advance and facilitate the marketability of SUNY innovation and the protection of SUNY intellectual property. As part of this comprehensive commercialization and economic development portfolio, Matt manages system-wide initiatives that support faculty to fund and develop innovation and assist SUNY-affiliated companies to effectively operationalize their business. So today, Matt's going to be talking about the tech transfer and buy Dole. And last but not least is Kira Alvarez. Kira serves as the legislative consultant for the American Bar Association section of IP law. In this role, working with the ABA Governmental Affairs Office, she advocates on behalf of the section before Congress and the executive branch, including the USPTO. Kira is going to wrap up our session today with trying to keep you guys awake on 101. Okay. So Adam, I know you haven't really been feeling that well. I don't think you're really tired, though, from your illness. I think you're tired from your 2 new puppies. So you got to tell people what their names are.
Oh, I have 2 8-month-old beagles, a boy and a girl, litter mates, and the boy is Edison and the girl is Tesla. and yes, they fight, but they also love each other.
Okay, so let's start off on the efficient infringement. And I even had to kind of look this up because I wasn't really sure what people were defining as efficient infringement, which really is the deliberate piracy of inventions. So we seem to hear more and more stories about inventors and SMEs, suing large companies for patent infringement, such as the recent news about Sonos suing Google. Let's start with that. If you could just give a real short background on Sonos versus Google, and then talk about efficient infringement for us and tell us if this is a new phenomenon or is this something that's just been there for a long time?
It's a great question. So the Sonos versus Google case, which recently hit the news. So it's a kind of a very common story now. So Sonos is a relatively small company, an innovator in Wi-Fi and networked speaker systems that could be voice controlled. And when they were a small company and still are relatively a small company, they were very excited that Google was interested in licensing their technology and entered into negotiations with them to use their technology. Google was not manufacturing speakers at that time. And same with Amazon, and then of course within a year or two, a few years, all of a sudden Google Home comes out, and Alexa and the various speaker systems come out, and lo and behold, these speaker systems, which are being sold for much cheaper price than what Sonos has to charge, because Sonos incurred all the R&D expenditures and the risk in developing this technology, what incorporates their technology. And they said for several years they had been trying to negotiate with Google and trying to force them to recognize that they were stealing their technology and that they should be paying them a license fee for this. And Google was essentially telling them to go pound sand. And so they did what you have to do when eventually you're forced by a deliberate infringer who refuses to negotiate with you. They sued. They sued for patent infringement. But this is becoming a quite common story, and the day after the announcement of the suit, there was a prominent article that said Sonos has already lost in its lawsuit against Google because what Google is doing is become a very common practice by large companies today that, that take advantage of a weakened patent system. So the context is that for the past 10 or 15 years, of course, as Brian mentioned in his opening remarks, that the patent system has been under a tremendous amount of stress from all branches of the government, from the courts that have been weakening or eliminating patent rights, such as in the 101 space and patent eligibility doctrine, removing the ability to obtain injunctions in the eBay decision in 2006. And by regulatory agencies like the Federal Trade Commission, investigating and bringing enforcement actions against patent licensing companies, and with the unending onslaught of legislation characterized as patent reform legislation, but the nature of all of this proposed legislation for many, many years was the elimination or weakening of patent rights. And so for large companies that have massive stockpiles of cash, Apple has $250 billion in the bank, you know, for them it's just a quick and easy economic decision that it's much easier and better for them, at least in the short term, to take someone's patented technology and infringe it. And tell the now hapless inventor or small company, well, you just have to sue us because you're going to lose, because we'll either have your patent invalidated on a 101 summary judgment motion, or we'll file 40 petitions against you at the PTAB and have your patents invalidated there. And even if you make it through, you know, 10 years of litigation, you still won't get an injunction, and you'll get very little in damages. And so this is a practice that wonkish people refer to as efficient infringement, because the company is deciding that it's more economically efficient for it to infringe. But historically, this has simply been a practice that's been known as called piracy. This is piracy. This is theft. Theft of other people's innovations and property rights. It has occurred. There are lots of stories throughout history of large companies and pirates taking innovators' technology and patents. But it hasn't been an institutional problem and an established business practice by many, many companies, particularly in innovation sectors of the economy like the high-tech sector today, that it has become in recent years because of the changes in the patent system that we've had.
So just touch a little bit on how does this end up actually being cheaper in the long run for the large companies, and how are damages actually awarded?
So the reason why it ends up being cheaper in the long run, right, is that first of all, you're imposing tremendous numbers of costs on the patent owner, who has to pay lawyers now to bring the patent lawsuit. So these are what economists call transaction costs. So you're imposing tremendous numbers of costs on them. And like, as I mentioned, Apple Computer, their legal department had a $1 billion operating budget. That's more than many companies bring in gross revenue every year. And so for them, this is just I sometimes joke that they spend more money on providing coffee to their employees around the world than they would spend on having to file the motions to dismiss and the serial petitions at the PTAB, and continually dragging out the process, threatening the invention. From the large company's perspective, it's largely win-win for them, right? So they either, they suffer nothing except for small amounts of loss, relative amounts of loss for them to file the petitions at the PTAB, where they will potentially completely invalidate the patent. They suffer nothing filing 101 motions to invalidate the patent for being ineligible subject matter. They suffer nothing by drowning the patent owner with discovery motions and dragging them through depositions and digging up pieces of so-called prior art and all sorts of nooks and crannies of the universe, dragging out the trial for as long as possible. Meanwhile, small companies that live on a day-to-day basis, or individual inventors like Josh, are watching their savings get eaten up, right? And so, and of course, inventors and companies are intelligent and rational, and they foresee this, and the large companies foresee this, and so very oftentimes, lawsuits aren't brought, right? The Sonos case that is significant because they sued. I mean, this works as a practice, and one hears very often from small companies, SMEs, and individual inventors that that their technology was stolen, and they were basically told to take a hike. The fact that you should be thankful that we're not going to bring petitions against you at the PTAB and wipe out your patent. So go away, or we're going to make life even worse for you. And for these companies, this is a rounding error for them in terms of the cost that it's imposed upon them.
Okay, Kira?
I was just going to add, it's funny because if that were a Chinese company it replaced Google by a Chinese company, we'd call it trade secret theft, and we'd be all up in arms, and we'd start a trade war over it, right?
Yeah.
Because that has been the case with Chinese companies when they've stolen U.S. technology in a very similar manner, and we've gotten all up in arms about it.
Okay, so let me just go a little further with this and say, what evidence is there that links reliable and effective patent rights with increased innovation and economic growth?
I'll just quickly say that just one often hears from people, oh, there's no connection between patents and innovation or economic growth. And while this is a conventional wisdom that is held by many academics and commentators, it is completely and utterly false. The overwhelming weight of evidence that economists have looked at and historians have looked at and social scientists have looked at for decades has been that there is a connection, a correlation between countries that provide for reliable and effective patent rights. So allow for injunctions for infringement and full damages, and allow for licensing of those rights in the marketplace. That countries that provide that through their patent system and provide property rights to the innovators who produce through the fruits of their labors all of these new incredible innovations, that these countries have growing, flourishing innovation economies and flourishing societies. It's the same correlations that one finds with property rights in land. Right? There is no single one study that you'll ever find by an economist that says property rights in land are causally linked to economic growth. But what we have is an historical pattern and massive numbers of economic studies that repeatedly find the link, a correlation between the two. And you have the exact same correlation and link with property rights and innovations as you do with property rights and land with respect to economic growth, innovation, and flourishing societies.
Okay, so we've seen recently some of these large verdicts that patent owners have gotten, such as the $1 billion award I think that Caltech got against, it was Apple and Broadcom, right, for patent infringement. Is this a sign that the patent system is still doing well for innovators in getting their patent rights?
Some people have remarked that this $1 billion jury verdict that Caltech got against Broadcom and Apple for patent infringement is an indication that everything is fine. And in fact, it's the exact opposite. Yes, you do get large verdicts, but part of what the policy of efficient infringement of piracy works is that they have effectively diminished the legal requirements for what it means to receive damages, as well as the inability to obtain injunctions. And so what a lot of these companies know, what Apple knows from its own experience, both as a plaintiff and as a defendant, is that on appeal, it can reduce these awards by as much as 50 to 70%, or if not, eliminate them completely. Apple learned this as a plaintiff when it sued Samsung, and it got over $1 billion judgment. And it's still litigating, but the last time that that it went to the Court of Appeals for Federal Circuit, it was reduced by over 50%. That Samsung had received against Apple. Apple has repeatedly succeeded in diminishing and eliminating the patent rights of Vernex, which sued it for infringing its patents on its FaceTime technology. Vernex also got over $1 billion or multi-$100 million of damages awards, and it went to the PTAB and got most of Vernex's patents invalidated, and has succeeded in eliminating and reducing by over 50% those damage awards as well. And the story is you see the story again and again and again. Carnegie Mellon received a massive patent infringement award, and its damages on appeal were reduced by over 70%. because part of the pressure on the patent system has been also strategic litigation campaigns by these large companies that not only have eliminated injunctions, but have reduced the standards by which even patent owners can obtain damages. And this is what contributes to this policy, this practice, this business practice now of deliberate infringement, because it's cheaper for them, and they know it. Great,
thank you. Josh, let me turn to you. I'm going to start out with, we've talked about this in the past as well, that your invention, bunch of balloons, was stolen by a notorious infringer who convinced the PTO to revoke your patent under a controversial procedure of the 2011 AIA. So with that somewhat adversarial or a controversial statement, I would like to ask you to tell the audience what your story really is.
Sure. For those that haven't heard it, I'll give the shorter version. I quit my job back in 2006. I was at Texas Instruments as an engineer, and spent 7 years grinding away trying to bring a product to market, various products, and wasn't working out, wasn't paying the bills, wasn't getting ahead. And early 2014, the middle of winter, I go back to trying to solve this problem that's plagued humanity for 2 generations, and that's filling and sealing water balloons. And it was one of many things as an inventor I was kind of tinkering with, but this was the one that just grabbed me year after year. And I worked it out during that last 3 weeks I had before I had to go back to punching the clock and working for a corporation. Got a prototype worked out, put it on Kickstarter. It went viral. It was unbelievable. We raised almost $1 million from 22,000 backers who thought it was a good solution to the problem of filling water balloons. And so I was in business, had lots of demand for the product, lots of orders, lots of licensing inquiries, partnered with the company, family-owned toy company who was ambitious and aggressive and disruptive, and they saw the possibility. We partnered and began to go into building a factory and mass production for this product, where we had demand for millions of units for the next season. We were about halfway through that process, and the knockoff showed up on TV, advertising buy one, get 2 free, act now, free shipping and handling. This was the classic impulse as seen on TV item. This wasn't, and so as an inventor, you expect to see knockoffs on Amazon and eBay, Chinese imports. This was a major American company that's been in business for almost 4 decades, and their business model is copying successful products and putting the rights owner out of business. And so there's been books written about this company, and it appeared that I had a formidable problem on our hands. So no inventor's ever won against this company. They've been sued over 100 times, a lot like some of the big tech companies that we've been mentioning this morning. They had never lost. They had never been to a jury trial. No small business can get there. So we got our patents on a fast track, so that part of the system's working. Thoroughly examined, got a patent issued, and they don't care. So these guys are like, what are you going to do with your patent? Give me a paper cut. And so you have to go to court, assert the patent. We moved for a preliminary injunction. They finally had to put on a defense, and I kind of thought, you had to claim that you used a different technology in order to avoid liability for infringement. And that wasn't going to work because we caught them. They copied exactly my product. So plan B was to challenge the validity of the patent. So they said all sorts of arguments. It's unbelievable the number of arguments that attorneys are allowed to file in these cases. But their favorite one was no one knows when a balloon is substantially filled with water, so it fails Section 112. Another one was it's obvious you just combine water balloons with rubber bands and soda straws, and that doesn't meet the requirements of 103. These arguments just fell completely flat in the district court. The judge granted the preliminary injunction. They appealed. They're still going to bury us in litigation. They don't want to stop. We come to Washington, massive expense to fight an appeal. We win the appeal. Meanwhile, this is about a $1.5 million project so far, which puts most small businesses out of the game. But we were able to survive. They come back to the PTAB. They make the same arguments with the same expert, and the PTAB cancels my patent. They're enjoined by the Article 3 court. The patent office says they're not. They respin the product, rebrand it, do it the next year. The whole thing starts all over again. We hire an expert economist to prove irreparable harm. His fee is $750,000. They make more arguments. They lose in court. They go back to the PTAB. They win at PTAB. I come to Washington and say, what's going on? I go and talk to the Patent Office. I talk to the Judiciary Committee. I meet these guys from U.S. Inventor, and they kind of show me the way around. And meanwhile, we keep selling product in the toy aisle, and they're trying to put us out of business in the checkout aisle, and we just keep paying our bills. It's $75,000 every week. Every week, $75,000. It's what I was making every year when I quit my job. But we're fortunate to pay the bills. I come here, kind of shine the light on what's going on, and those two factors are the key in the patent system. You've got to have really deep pockets, and you've got to have influence in the government. And I won an appeal. They changed the PTAB judge on my second and third patent. Things start turning around. I start getting ahead of these guys, and they realize they're hiring the biggest law firms in the industry, and they bring in everybody. David Boyce, Morgan Chu, Ireland Manella. They're like, this is the formula. It's always worked. We're going to stick with it. And finally, after 4.5 years, they had 4 injunctions piled up on them and their customers. They had probably about a $20 million annual budget. Fortunately, this was only a $1 billion corporation that I was up against. So they looked at the numbers. They said, well, it's going to cost us $20 million for the next 10 years to fight this guy. And so last May, they came to the table and they paid us what they owed us, and they exited the market. So I came out the other side, and I survived. But meanwhile, many other emitters along the way obviously can't survive that gauntlet. And so now I'm volunteering with U.S. Inventor. I might have skipped to the next question, but that's the story.
Well, the Wall Street Journal, you won your infringement case last year, right? And the Wall Street Journal categorized us or characterized it as a $31 million truce, right? So what's the status today? The damages, your patents at the PTAB, et cetera?
Yeah, I did skip a question, didn't I? They did surrender, and so that means everything was dismissed. The challenges to the patent are dismissed. My patents are still valid, but they're not presumed valid, right? There's no estoppel. Fortunately, though, given the level of effort they put into challenging my patents, that we prevailed, I think we're in pretty good shape. Now it's unlikely that someone else would come along and attempt what they did. So it was a settlement. Adam described these cases that have been appealed and then reduced to 50 or 70%. Even those cases, many of them are still pending. Others settled. So the litigation system doesn't resolve disputes, and it can shorten them. So once one side gets ahead, we got far enough ahead that we were able to win a stipulated injunction and recover most of our damages. So they paid the $31 million was $12 million in lost profits. It was multiplied by 2 for willfulness, and we got $6 million in attorney's fees. And then there was a payment to settle some of the other pending cases. So it's
okay. So for others,
my litigation's over now.
So other small and medium-sized enterprises, what advice would you give them? I mean, would you recommend contingency representation, licensing? What direction would you suggest they try to go?
Yeah, I thought about this a lot in the Sonos case, so I think that I don't know if they understand what they've gotten into. So this is a 10-year fight, and then if you win, survive 10 years, then you get paid a reasonable royalty typically, and so that means the infringer gets to keep most of their profits. Inventors and small businesses are in a predicament right now. So I would say, I tell inventors, until we can restore reliable patent rights, look at trade secrets, look at minimizing your investment. So you can invent, join the maker movement, join the open source movement, invent on the weekends with your spare funds. Do not put your life savings into starting a business that relies mainly on the supposed exclusive rights of a patent. because you can't rely on that. So be creative. Inventors are very creative, very robust. And so knowledge is the key for these guys. They just need to know. I had no idea going in that a patent, despite the language on the cover of the patent, is not the right to exclude others from using the invention. So I'm educating inventors that that's not true. I had no idea the patent office could take back your patent. So letting inventors know that that's a real threat. And so those are the things. Just be aware, be knowledgeable, and then you find a way when you're armed with knowledge. So.
Great, thanks, Josh. Matt, let me move to you. The Bayh-Dole Act, which is celebrating its 40th anniversary, I believe, this year. It was passed in 1980. It's a landmark legislation that fundamentally changed our nation's system of technology transfer. It enabled universities to retain title to inventions and take the lead in patenting and licensing some really groundbreaking discoveries. But if Senators Bayh and Dole were here today, would they think that it was a success?
Mm-hmm. Great question. Thank you. I believe the answer is yes. Simply stated, I think that the Bayh-Dole Act was implemented to ensure public utilization of the results of federally funded research. Prior to Bayh-Dole, I believe approximately 28,000 U.S. patents were held, or the federal government held title to 28,000 U.S. patents, and less than 5% of those patents were partnered with industry partners to turn that research and that intellectual property into commercial products that can transform lives. Post Bayh-Dole, in the last 25 years, over 80,000 U.S. patents have been issued that have lineage back to federally supported research. Over 200 new vaccines and drugs have been introduced to the market that, again, draw lineage back to federally funded research. In the last year, the Association for University Technology Managers, which is kind of the professional organization where all university technology transfer offices report their metrics up to, compiled a report saying that in 2018, 828 new products and services based on federally supported research and funded and supported by universities were introduced to the market into products and services that transform lives. So I believe yes. And I believe we can do much more.
Okay, so the Bayh-Dole Act itself encourages universities to partner with industry, kind of translating the inventions into products. This should theoretically benefit the public. But do you think the mission of the universities and industry are at all misaligned? And if they are, what's causing the misalignment when the university is trying to seek ways to commercialize their products?
Mm-hmm. So most universities' missions are to train students, to do research, and they're not so minded and profit-driven. Industry is profit-driven, so those two missions are misaligned, especially if the expectation is that universities are supposed to license their intellectual property with industry partners that are actually going to do all of the work and invest all of the money and time to move that intellectual property, which, coming from SUNY, is very, very early stage. Takes decades to develop into products and services, take billions of dollars to, especially if it's a life science or drug or vaccine, to move that into a commercializable product that's then sold. So understanding those dynamics, I think, is key. From the university perspective, we've gotten comfortable with not calculating the number of dollars received from licensing transactions, but we look at the broader impact of those deals that are done with industry. We try to negotiate for additional experiential learning opportunities for students with our company partners, and we try to extract additional value, understanding that our industry licensees are doing most of the work and investing more money than a university probably ever will in moving that product along the commercialization life cycle.
So is there a common business model that the universities as a whole try to follow, or is there something specific with SUNY?
I think the common model for most university technology transfer offices is to first use the provisional application. I think is a standard at most university technology transfer offices, and we try to do the most we can to file and build strategic IP portfolios in the most efficient way possible. So We are constantly trying to market our technologies and our IP portfolios and adopt new licensing practices that help us be more favorable in the eyes of our industry partners. In the last decade or so, SUNY-specific licenses with startup companies that we formed is increasing exponentially. Now, about 75% of our licenses, of licenses we negotiate with our industry partners, are startup companies that we form at the university. So that caused a mindset shift where we have to get comfortable now taking equity in lieu of cash in some of those companies and modify our policies and practices where typically we'd expect a high upfront fee payment for a license if we were doing a license negotiation with a well-known company. Now we have to get comfortable in seeing that license as an investment with that company partner with the overall goal of supporting that company grow strong and possibly lean just to introduce a new product or service that can transform lives.
Okay, so looking sort of at trends or to the future, is there anything that you would suggest to the industry, whether it's the startup or the large company, that would help in their collaboration with SUNY or with the university environment?
Yeah, I think our SUNY has gotten comfortable with not seeing revenue, understanding that the technology transfer operations within our system are not seen as a profit center, where we try to look other ways to extract value from those partnerships that we're trying to make. So I think as the university is trying to modify and modernize its practices and recognizing that we do need our industry partners to help us commercialize our intellectual property, keeping in line with the legislative intent of Senators Bayh and Dole with the passing of the Bayh-Dole Act, I hope that our industry partners can see that as well, where we are a hotbed of innovation. The universities are a hotbed of innovation and research activity. We have access within SUNY. We graduate 400,000 students per year. That's a lot of expertise that can be leveraged and new recruits for job openings, et cetera. So I hope that, and we try to always have a dialogue with our industry partners to have them look deeper inside within the university, not just at our intellectual property portfolio, but look deeper inside of our unique tools and infrastructure that we can utilize to support any additional research programs for our industry partners, and look deep inside at our expertise that we can also offer our industry partners. Great.
Okay, last but not least, let's turn to 101. The one that everybody talks about all the time. Some of you may recall that AIPLA, ABA IP section, and IPO about a year and a half, almost 2 years ago now, came up with a shared principles document, and then AIPLA and IPO came up with a proposed legislative solution to try to get the conversation started. So what's the problem today with 101? And why can't we get it fixed?
So before I start, two caveats. One is, obviously, I'm speaking here on behalf of myself, not on behalf of the ABA IP section. The other is, I'm actually not a patent lawyer. I play one on the Hill, but I'm actually not a patent lawyer. So for those patent lawyers, excuse any technical glitches I might say. I thought what would make sense would, let's take a step back. What does 101 actually say? And I have my statute right here. Inventions patentable. Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent therefore, subject to the conditions and requirements of this title. Period. That's pretty good. Diamond versus Chakrabarty, 40th anniversary, says, that's expansive language. The problem comes with later Supreme Court cases, right? Alice and Mayo, where they create implicit exceptions saying, well, if it's a law of nature, actually it's not an invention. If it's an abstract idea, like filling the balloon with water, that's an abstract idea. If it's a natural phenomenon, like figuring out how to separate father's DNA from the mother's bloodstream so you can figure out what the fetus's DNA segment looks like, that's a law of nature. That's a natural phenomenon. So that's part of the problem there. The other problem is they've brought in concepts from 102, 103, and 112 Because under Alice and Mayo, you now have to think about not just what these words say, but you also have to say, does it have an inventive concept, and is it routine and conventional? And if so, then it doesn't fall under 101. So you're now looking at obviousness and novelty as part of the 101 discussion, inquiry. But actually, the issue is that 101 has become an easy way via summary judgment to get rid of patent cases. And so if you're a defendant, you just say, hey, those balloons, that's an abstract idea, it fails under 101, and you don't even have to get before a jury, you don't even have to get to the evidentiary phase. And it's a handy tool for a lot of companies who want to go and attack patents. So that's the problem. How do we fix it? Well, I think we have to fix it by changing the statute. And that's where we are right now. And I think there's a recognition on the Hill that 101, the pendulum has swung far too in one direction. And as a result, it is impacting our innovation. As I said before, it has had significant impacts on the life sciences and particularly the diagnostics fields. But more recently, we've had cases in the federal circuit where was it garage door openers and drive shafts have been seen as abstract ideas. So I think there is a recognition on the Hill about the need to fix it, but therein lies the rub.
Well, tell us what's going on the Hill then. Tell us what's been happening for the last probably, 15 months now? 14 months?
Yeah, and I would say, so I think the Senate, Senators Tillis and Coons recognize that this has been a problem. They held a series of roundtables and then a series of hearings on the problem. And they were trying to have a very sort of open discussion with the relevant stakeholders and with both sides, because with any legislation or with any treaty, you're going to have a negotiated compromise. And I think they were trying to sort of thread that needle. I think for those who might have attended the hearings, there are some on the other side of the discussion who said, well, first of all, as I said, it's a handy tool. It allows you to get out of what many companies consider abusive litigation. So they said, if you do something on 101, then you have to counter. If you're going to make it easier to get a patent, then you have to pass some litigation reforms. And I think the thought was that what would be necessary would be sort of doing something sort of on the expansive and overbreadth on 112 and functional claiming. And so there was some discussion of sort of a compromise with some changes in 101 and maybe some changes in 112. But as with everything, the devil's in the details. I think where we are now is, those who want. I think it's a matter of tactics. There are some in the pro-patent side of the field who believe that it's important to have a very strong opening draft of legislation for various reasons. One of which so that perhaps the Supreme Court can see sort of what these drafts look like and sort of take a hint in terms of, maybe we have gone too far and maybe they'll have some case law that sort of, ratchets back some of their jurisprudence that had happened previously when the AIA was in discussion. However, I would say that, given the fact that the Supreme Court at the beginning of January said we're not touching 101, we're not touching subject matter eligibility, that's probably not a good rationale for having a maximalist position opening start. And there are others who, from a negotiating perspective, think that it's important to have a very maximalist approach on 101 and sort of an ideal approach to 101. Because it is going to get watered down, because everybody knows it's an exercise in sausage making, and so you want to start with the least amount of give so that you end up closer to your end than to the other side. So, but the issue is going to be sort of, I think politically, my understanding is that a bill that doesn't show some amount of compromise, that doesn't show sort of a recognition that there are valid arguments on the other side of the coin, that there has to be a bill that doesn't have a draft bill that doesn't have that won't even be feasible to introduce. So I think it's incumbent on those who want to change 101 to really think about sort of what's a position that's not a maximalist position, but that accomplishes the majority of what we want, which is a thriving, innovative ecosystem, but also recognizes some of the criticisms that others in the room might have, such about, particularly with respect to functional claiming, and have a start and use that as a starting point.
Thanks. Adam, I know that you testified in June. I know you have a lot of thoughts, but tell us what your thoughts are for what the problem is and the solution. Where do you think we're headed? What's the trend, or what do you think we can accomplish? Let's say in the next 12 to 24 months.
Well, I have no special insights on these issues, especially as a professor. So I defer to the experts and the people who are working on the ground on these important issues. But I can say, I mean, that it is having an impact, and it's having an impact. In the comparative statistics are starting to show this. So I and a former colleague of mine, Kevin Madigan, we published an article and did a follow-up post about how there are well over 1,000 patent applications that were either rejected at initially or final rejections at the USPTO on 101 grounds, and the same patent applications on the same inventions were granted by the European Patent Office or by China. And a lot of these patent applications are on diagnostics, on treatments for diabetes and cancer and other types of maladies, and this portends very, very darkly for the future of innovation economy, and correlates with what we're hearing from venture capitalists and other people who are saying that we are offshoring innovation in this country. We are sending venture capital funding to Europe and to China. And why is it going to those places? Well, because not just can you get a patent, I mean, without arbitrary decision making that you see by judges who say an automobile axle, patent for making an automobile axle is an unpatentable invention because it's just an application of laws of thermodynamics. Literally, that's what the court said. You have a patent on classic 19th century technology, right? I mean, and now you can't even get that patent anymore because it's an application of the laws of physics. Well, everything's an application of the laws of physics. Why are we issuing patents at all anymore then, if that's your reasoning from judges? And you don't have that in China. You don't have that in Europe right now. And even more importantly, you can get injunctions in China. You can get injunctions still in Germany and in other jurisdictions. In fact, it was a real I think an important framing point that in the extensive patent war between Qualcomm and Apple, that Qualcomm actually got injunctions against Apple. It got them in Germany and it got them in China. Yeah. It never got an injunction against Apple in the United States. And protecting your property rights, stopping infringers, and injunctions are not just about stopping infringers. As everyone knows, injunctions are the backstop for commercial negotiations. You can't have a contract. You can't have a free market exchange if one property owner can't say to the other, you're not allowed to use my property without first negotiating with me and entering into a contract with me.
I think in terms of the law and the Supreme Court, I think where we really went off the edge was when we forgot about practical application. Yeah. Because when you look back to O'Reilly v. Morse, the court is saying, look, you can have these laws of nature and those aren't patentable, but if you have the practical application that doesn't preempt other uses, then that is patented. That can be patented. Yeah. And it's really this notion of the practical application that really has sort of thrown us off the deep end. I think, it's interesting because at the same time, it's been unwieldy, this Alice Mayo test. I will give credit to the PTO with their 101 guidelines for examiners, where they've tried to come up with sort of some classifications whereby And they're trying to give the patent examiner sort of some more guidance on how do you determine that something's a law of nature and something is a natural phenomenon. And I think that has helped. But the problem is fundamentally it's still a bad solution, I guess. It's a piecemeal sort of jerry-rigged solution.
It's not a solution because, the patent office will issue the patent and then a judge will invalidate it.
Right, exactly.
Right? And the judge will apply the Alice Mayo framework in the way that they've been applying it.
Right, exactly.
So, because the USPTO can't change the law because they can't change the Supreme Court's decisions. And the Supreme Court clearly indicates that it believes that nothing is wrong, right? It's denied now approximately 50 cert petitions.
Right.
Since in 2014, asking it to revisit this area. By the way, I don't think it should grant cert petitions, right? If you were a betting person, what would the Supreme Court do in this area if they granted a cert petition? More likely than not, even if they thought they were fixing it, they would screw it up again and make it even worse, right?
No, I'm with you. I don't think looking
Congress
to the
has
courts.
to fix this.
I don't think looking to the courts to fix this is the way to do it, because I think there were some people who were holding out hope that after the plea by the Federal Circuit in Athena, that the Supreme Court would take Athena and then they'd fix it. But I was always skeptical of that. I prefer a legislative fix that's sort of a compromise, a grand compromise that's worked out.
Congress has to step in and fix
Yeah,
this.
they really
This is exactly what a balance of powers provides for. The Supreme Court has gone off the reservation on this issue. And is undermining our innovation policy in this country. And it's exactly the point where Congress needs to step in and say, these are our statutes.
Right,
we are the ones authorized by the Constitution to create and protect patents. And we need to make clear to the innovators that we will do what we historically have done in this country since 1790.
Yeah, and like I said, reading back to 101, there's nothing in there about laws of nature or natural phenomenon or abstract ideas. And so has to be Congress that says those terms aren't in there, or don't read them in there.
So Matt, you weren't expecting this question, but I got to ask anyway. From SUNY's research and all of the work that you are doing, what is your 101 problem? I mean, do you have a 101 problem? Are you seeing this every day? Are you seeing it less often? How does it affect you guys?
I mean, certainly we file less patents. I mean, it's caused our patent strategy to kind of be redesigned. We're filing less patents directed to diagnostic technologies based on the decisions with the Mayo case. But this conversation also makes me think about now that AI is becoming more prominent and hearing the language of 101, the first word is whoever. So how would 101 be treated if it was actually a machine creating that invention, or if the individual driving the machine or creating the AI that enabled that particular artificial intelligence to invent something brand new? That's causing a lot of dialogue within our system and our university, and understanding now that we see artificial intelligence and quantum computing and communication being a real research priority area for SUNY. So we're trying to adopt and understand how we should pivot our IP strategy and our prosecution strategy with those technologies, and making sure that we support the faculty members that are doing research in that space by having good controls and strategies for protecting those types of inventions. And I think the 101 issue was going to come at odds with those AI
So you did talk about filing fewer patents. Do you have any specific strategies that you're really sort of implementing right now, or something that you've implemented recently that you could share?
Mm-hmm. We have a really tight system of since technology transfer offices are not a profit center, so we don't have unlimited patent budgets to pursue protection for all of the technologies that are disclosed to our technology transfer offices. So what we do internally is we have a prioritization framework, and those technologies that pass through that prioritization framework, where there's a commercial application for the technology, or a market exists for this technology, it's protectable. All of that kind of gets scored on a balanced scorecard type of approach to help inform what our protection strategy is going to be. And that's a very transparent process with us and our faculty members, because for us within the university, our main customer is our faculty members. We want to make sure that they are with us and making and understanding the decisions that we make from an IP strategy point of view. So we go through that balanced scorecard type of approach and understanding the market, understanding if a customer actually exists out there that would eventually utilize the IP or the technology further down the road. And depending on whether or not there's an entrepreneur within our community and a management team that's ready to take on the challenge of forming a company and building a commercialization plan around that intellectual property is also something that we are now looking more frequently to take advantage of. So we're trying to build more entrepreneurial teams because we know that it's very unlikely that any of our IP is going to be partnered with a company that has deep pockets to help with that development. More companies nowadays are looking at the smaller companies to de-risk that technology a little bit before they're willing to take their piece of the pie.
That's great. Let me just ask the panelists before we move to question and answers. Anything else that you want to share with we're running a little bit ahead of time, so anything you want to share on 101 or any of the other topics, Bayh-Dole, efficient infringement, or Josh, maybe IPRs?
Well, I had a little perspective on the 101
Please.
Process. We participated over the last year or so, and maybe I would jump off of what Kira said about compromise versus a maximalist approach. We looked at the AIPLA proposal as the compromise. I didn't consider that a maximalist approach. What I saw there was codifying some exceptions. So you had natural laws would not be patentable, mental processes would not be patentable, and so we were kind of stunned when the process started off with, well, if you want to fix 101, you have to break 112. And that just was, it really stunned us that was how, maybe we're novices at this legislative process, but we're at a point where we can't enforce our patents in the status quo. And to start off an improvement to the patent system with, we're going to disallow functional claiming, that's the language we use as inventors to describe what we invented. And having just come through an intense litigation, I know exactly what the infringer is going to do if functional claiming language is passed, like what was proposed. They're going to take apart every term in our claims just like they do today, and we're going to go through multiple motions and claim constructions, and they're going to find 15 functional terms in my claim, and then they're going to say, well, I don't see structure for that in the specification, I don't see structure for that in the specification. And so, we thought that, and I have to give credit to the senators and the committee, they actually did listen. When we went and explained this problem in the hearings, they did put the brakes on that. And so now we're at the point where it's frustrating, it's hard on innovation to not be able to rely on patents, whether it's on a drive shaft or a vehicle charging system or certainly any type of technical improvements. We have a problem now. But we can't start off the process of fixing it by a deal with the devil to make sure we make it worse. That's kind of where we're at on this.
I'll just say that, as long as the understanding is 101 is a litigation tool, we will not have reform, because that's not the purpose of Section 101. 101 sets forth a basic requirement of what it means to have a valid patent. It's not in the litigation section. It's not part of Section 271 or any other sections or Section 284 about litigation of patents. It's part of the set of provisions that defines what it means to receive a legitimate patent on a legitimate innovation. And at the Hudson Institute, we released a short issue paper on this confusing mix of Section 112 with the 101 reform debate by patent scholar Crispin Asenga that really, I think, effectively and nicely addresses this mismatch and how the Section 112 came in because of this. Well, this is an easy litigation tool, 101 right now, under Alice Mayo, so we need another litigation tool somewhere else. And Section 112 isn't a litigation tool either. Section 112 is another provision that sets forth the basic requirements for what it means to have a valid patent.
But it is listed as a defense to infringement in 284, whereas 101 is not listed.
Yeah. Although, having a valid patent, right, you can, as a defense, assert that a patent is invalid. And you could always assert that a patent is not patentable subject matter, even going back to the 19th century. But that doesn't make those sections litigation tools. That's not what that's not their function.
It's not, but it's what it has become. And so if you start the discussion without the realization, the reality that that is what it's become, and that's what the purpose and the utility to one sector of our economy, they're not going to let go of that tool without getting another tool. I mean, that's just negotiations 101. And, the thing with 112, I mean, think about, you already have the court in Citrix versus Williamson talking about 112 and how 112 should be sort of interpreted. And so the thought is, if you're already living with a 112 solution, what about, codifying a Williamson test? Because you're already living with it. I'm not advocating for this. I'm just sort of putting that out there as a possibility. Right. Let's think about it, because I was a U.S. trade negotiator, and we always went in with the most maximalist position ever, because we wanted everything and we want everything. Most of the time we got most of everything, but there comes a time when you have to start compromising. You start, there's stuff that you've put in there, and you have to start letting go of it, because in order to create motion. Because if not, you're just going to be sort of for months and months just at odd ends. And the issue is, with legislation, on legislative negotiation versus a trade negotiation, a legislative negotiation, you have to find your window of when you're actually going to get legislation that is actually going to move. And I think last year we had a lot of momentum to move. We had sort of 4 members of Congress, at least 4 members of Congress, that were really invested in getting this issue moving, and invested a lot of staff time in trying to find a solution. And at the end of the day, it went up in smoke, and I don't know when that window is going to come up again. And that's the issue, because they've moved on. And so, yes, I think having a maximalist position is a good thing, because it means you get what you want. But at the same time, you have to figure out, if you have the pretty perfect solution, but it's not going anywhere, what use is it if it's behind glass?
I have an observation. I don't know, it's not a strategy yet, but it's become clear to me after being involved in this for well over a year that there's a common theme. It was raised throughout this panel is enforcement and adjudication is where the problem. It seems like there's kind of a consensus forming. And it's interesting, because last time we talked about litigation reform, it was going to be really terrible for innovators. But we're kind of back around to the problem is it's too difficult to sort out disputes over patent validity. It takes too long. It costs too much. And I don't know. How do we get to where, when the patent office issues a patent, we generally rely on its validity, because there's all this desire to find new and better ways and more ways to invalidate a patent. Maybe we can find a solution path forward on streamlining resolution of these disputes. Just a thought.
So where are we going from here?
I think, part of the issue on the Hill is that during the AIA, this patent troll narrative really sort of took hold, this sort of concern that innovation was actually being held back by those who were trying to assert their rights. And I think that's still out there. And so I think we need more education and more sort of getting out the views of, Josh's views, SUNY views, that, we're no longer, if it's a diagnostic, we're not putting any money into patenting that, not really pursuing that. I think that narrative has to take a hold. So I think that's really important. And I think the people who really want to fix this have to really look deep and figure out sort of what are they willing to think of, and, what are they willing, there are powerful economic interests on both sides of the debate, and nobody's going to let go easily. And everybody has to take a step back and really think about sort of what is it that at heart is really the most important part. Do we really want to fix this, and what are we willing, what is important, but, okay, if I have to sort of live with that, if I have to live with the codification of Citrix, can I live with that? I think we really need to take a step back and think about that.
Any other comments before we open it up to the Audience? Okay. I think there's going to be some mics. Let's open this up to questions. John?
So I don't need a mic. So given the IPRs turning into something nobody expected, the numbers, how they're used, do you think adding a presumption of validity and just making it a validity decision, just like district court, would have some, would move the needle to something a little more fair? I mean, I'm not talking about the multiple petitions and all the other problems, but that single nugget that really, it always struck me that the only institution in the United States that does not give PTO credit for its work is
The PTO.
and it's not an examination, let's face it, it's decision-making process. So would that be a small nugget that would make a big difference in your view? Because I think it would. It would change the presumption, it would change the balance a little bit at least.
Anybody?
Josh, you've gone through this.
Yeah, I'd want to understand the mechanics of doing that.
It'd have to be a legislative fix.
Yeah, I mean, it depends on what you mean by presumption. I know when you go in front of a jury and you explain presumption to them, they understand this is a product from the United States government backed by the full faith and credit of the government. But if you're an administrative patent judge and you just write an opinion that says we did presume the patent was valid, we still find it would have been obvious.
It's clear convincing
Yeah.
evidence preponderance. I mean, it's 75, whatever the number is.
Yeah. But my point is that on a 103 decision, which 90% of these are, it's very subjective. And so whether it's a 50% or an 80% standard, you can still say it would have been obvious 10 years ago. So my concern is with the adjudicator, given him I mean, BRI didn't change anything. When they construed the claims under BRI, now they construe them under the Phillips, it hasn't changed anything.
Right, because it didn't make a difference. Presumptions of validity and clear convincing evidence, do you think would make a difference? I appreciate your point that you're saying they might not apply it, but assuming they apply it, like the federal circuit does apply it, I was a law clerk, I think I see judges look at how much evidence on review they have to decide. So do you think if applied correctly, it would be improved?
It should be, but we've got 8 years of experience that gives me pause to signing off on.
It's hard to predict what any one particular change would have because there's lots of other institutional dynamics that come into play. Some of them are identified by Josh, like the nature of the particular substantive challenges that are being made is at 103, the nature of the adjudicator. So it's hard to say, well, this one fix is the key. Now, would it be a step in the right direction? Yes, because the PTAB has been a largely lawless, out of control agency since its inception. And that's not
the professor that said that, not the radical inventor.
I can say that as the professor. And I'm on record saying this. But it's not the fault of the PTAB. I mean, Congress created an agency whose sole job is to cancel patents, impose no structural or substantive limitations on it at all, and it said, go do your job, go cancel patents. Is anyone shocked if I describe that in the abstract? Government creates an agency, gives it a job, eliminate property rights, puts no limits on how it will do that. And then 8 years later, people are shocked at what this agency's been doing. Everyone would say, well, of course, that's what happens. That's why we have a government of limited powers. That's why we have structural limits built into our government. That's why we require due process and things of this sort. Because the abuses have been well established and clear. I mean, John, you mentioned the serial petitioning. I mean, so the statistics have now shown that the reason why you have serial petitioning is because it works. That literally petitioners are cutting and pasting the language from earlier petitions, and the statistics on whether the grant on the follow-on petitions go up increase, even though it's literally the exact same petition. You have an increased statistical chance of the petition being granted on a follow-on petition when the exact same petition. So, I mean, this is an institution that needs to be fixed, and it can only be fixed, I think John rightly said, by legislation, because it needs to have baked into its structure the same types of recognition of both not just the basic procedural protection of rights that American citizens receive, but the substantive protection of the rights of property that all Americans receive as well and that patent owners have long received.
But it's a good suggestion, John. I appreciate it.
Okay, other questions? Brian.
Yes, from each of you, really. She's not letting me touch it because I have the flu. From each of your perspectives, if you could wave your magic wand, make one change to the patent system to make it better, what would that be?
Can I have your wands?
Who wants to go first? Matt?
From my perspective, the AIA has caused a lot of unintentional consequences that have impacted the way, specifically, we pursue our intellectual property portfolio. So if I had a magic wand, I'd revert back to pre-AIA times.
So if I had a magic wand, surprisingly, I would fix 101.
I'll keep mine narrow. I would make the adjudication of the Patent Trial and Appeal Board voluntary instead of mandatory, which it was for over 100 years.
So if I was Philosopher King, I'll incorporate by reference Matt's and add abrogating eBay and returning to the long-standing historical approach since 1790 that patent owners receive a presumptive right to an injunction like all other property right owners. It's something I've been working on for a while. There was no historical four-factor test, contrary to the claim in eBay that there is a alleged historical four-factor test. I'm sorry, I'm not saying this loud enough. There was no historical four-factor test, contrary to the claim that there is an historical four-factor test in eBay. I've just about finished rereading all of the 19th century patent decisions on this issue. And the number of times I found district courts or appellate courts applying a four-factor test is 0. So they applied typical equitable analysis for all property rights owners and providing a presumption that could be rebutted, but it was a presumption.
Interesting. Okay. Next question.
Hi. Thank you. I'd like to start out just with a request that, to some extent, we be a little careful with the acronyms. For instance, I think, Matt, you used an acronym when you talked about what your one change would be, and I don't know what the acronym was.
Oh, sorry. America Invents Act.
American Invents Act, because I admit that I'm not an expert on intellectual property. But I am a reporter, and I cover trade. So I'm going to ask a question that's kind of trade-oriented. Sonos has filed its lawsuit or its legal action against Google at the International Trade Commission. And obviously there are different venues in which you can prosecute a patent action. Why is the ITC venue attractive in some cases, if that is the case? Thank you.
Do you want to answer that, or I can?
Either one.
So the ITC, the only remedy you can get at the ITC is what's called an exclusion order, which is effectively an injunction. And the ITC still, although it doesn't apply a presumption of an injunction, it still applies a more kind of traditional historical approach to what patent owners have typically received for infringement of their rights. And therefore, the ITC right now is a more effective venue, a more effective forum for a patent owner to receive protection of their rights, although in a certain sense it's limited because the only thing the ITC can do is exclude imports of infringing products or services. You can't get domestic enforcement, but at least you can get an injunction, an exclusion order at the ITC.
But arguably, if a lot of the products are being built overseas, then if you stop the importation of those infringing products, that could be a good remedy for you.
Yes, but at least you get something, which then you go back to the infringer with and say, now we just have a conversation, the conversation we should have had before you made the business decision to infringe.
Did you have something else you wanted to add?
No.
Okay. Okay.
So I know the term patent troll sometimes gets overused. Is there a term that we prefer more now, or that one is more apt? Does that make sense?
To replace the term patent troll?
Exactly.
Patent owner?
Yeah, I think that's the answer. No, what I was getting at is that the conception was that anybody who had a patent and was enforcing it was not a true inventor, was somebody who had bought that patent like as a license and then was using that to enforce it against many different defendants who didn't realize that they were infringing, and so felt like they were being sort of mugged on the highway, kind of thing. But it was that presumption that it wasn't really somebody who had put their sweat equity into actually sort of, their life savings and their sweat equity into developing the product, that it was somebody who had bought this sort of the license or had bought the invention off of the actual inventor and then was just using it sort of to cash in. So that was sort of the narrative around when the American Invents Act was going through Congress, was that, patent rights had gotten sort of out of control. And so through AIA, the creation of the PTAB, through the eBay decision, and through the Supreme Court decisions, the thought was, let's rein in some of those patent rights and some of those rights that patent owners have. But as Adam was saying, I think the pendulum has swung too far the other way, where patent owners, legitimate patent owners, and you have one right, and inventors, and we have one right here on the stage, can't actually enforce their rights and can't actually, take that patent and get it to mean something.
There is no, we shouldn't use the term, but there's a distinction, I think, that is helpful, not in the law, but in the rhetoric and in the dialogue, because you now have patents that are underwater. They're being traded for less than it costs to produce them. And so if you get 1,000 of those and put them in a portfolio, you can assert them and get paid for them. And so for an investor in that situation where they're taking an asset that has been devalued through the system, they're still able to make a profit of it. And so when the policies and the court rulings and the equities are decided in that context, and then an inventor comes along who built a product and got scooped by a bigger competitor, he's treated the same way. And so under the law, I don't know, maybe they should be treated the same way, but the harm that's happening to innovation and to small business and the squashing of disruptive innovators is being, they're kind of being treated the same way. When they go to these 101 motions, when they go to the federal circuit and you read the papers, all that narrative is applying to all of us. And so there's a distinction there that we've suffered from because other investors have managed to extract value from these assets using. But yeah, we should be able to sell our patents and license them. But anyway, I think there's a distinction there that I think has been harmful to not recognize.
So we've seen the effect of a lot of decisions playing out in the real world, but we haven't necessarily seen the bottom of that effect yet. We've got the GIPC index, which again, had us U.S. at number 1, then number 12, then tied for second with 11 countries, then tied for second this year, the 4 countries. But what's indisputable is that there's been a degradation in patent rights. I think everybody now agrees across the spectrum. Have we hit bottom yet, though? Judge Michel was talking the other day about injunctions and how eBay has accelerated in its effect in recent years, and that it's now harder in the last 3 years than it was even previously to get injunctions as a result of federal circuit decisions. Have we hit bottom in terms of just if no new court cases are handed down, no new legislation passes, or are we still seeing a further degradation of patent rights?
I think we'll know that when we've hit bottom when China beats us at the quantum computer race and at AI. And so I don't ever want to see bottom.
Well, I don't know how close it was to the bottom. It was pretty distressing when the Attorney General throws up his hands and says we can't beat Huawei in a speech last week, and says the solution is to invest in Nokia and Ericsson. Like, we've given up on our innovators, it looks like. So we're pretty, I mean, that's a huge marker that's very, very distressing.
Well, the data is slowly coming out that things are really in a serious state, right? I mean, we dropped in the Bloomberg Innovation Index in terms of basic research funding. And the studies of venture capital funding, while gross venture capital funding is up or has remained largely stable. If you look at this, you break it down and granularize it by sectors, there's been a massive shift away from patent-intensive R&D, such as in medical diagnostics and biopharmaceutical treatments and things of that sort, to things like hotels and services and restaurants. These are not things that drive innovation economies or make for flourishing societies. And unfortunately, every time I think it can't get worse, right, Congress or the FTC says, hold my beer, right, and says, here, we're going to prove you wrong. And unfortunately, with the patent system, because it drives innovation, it drives R&D, and it drives development of new commercial business models that are typically of long time horizons, you don't see the effects for a very long time. Unfortunately, for many people, it will be dissociated in their minds that, well, 10 years from now, when we have fewer medical treatments and fewer diagnostic tests, right? People won't think, oh yeah, this is because they eliminated injunctions in 2006 and they became impossible under patent eligibility doctrine in 2014 to get a patent, unfortunately.
But I think it's also that we have stopped valuing innovation. We want everything, I mean, we've become sort of the lowest common denominator. We want everything as cheap as possible and now. But we want the cutting edge stuff, but we want it as cheap as possible and now. And we're not willing to pay for it. And so companies are realizing that they can't, you know, they're either going after they're going through the efficient infringement sort of way of innovating, because that's how they get cheaper products, or, you know, they're deciding that they can't invest in those areas, you know, for the pharmaceutical companies and the life sciences. You know, SUNY is like, okay, well, if we're not going to be able to do anything on diagnostics, I'm not going to get a patent there. And so it's just sort of, we just keep on devolving lower and lower and lower. And so it's a combination of the two things.
Yeah. I mean, historically, and I do a lot of historical research, I mean, you've had this pendulum swing, but it's the depth to which the U.S. patent system has been weakened and degraded in the past 10 or 15 years, we are outside of historical norms at this point. I mean, historically, patent owners have been able to get injunctions. Historically, patent eligibility doctrine was a relatively constrained, very narrowly applied. There were not many cases in which you would find it applied in any active sense. There was no PTAB before the American Vents Act of 2011. And so we're kind of in new territory at the sense in which we have put the strain on our patent system. And you know, our patent system was known as the gold standard. It was the benchmark by which many countries adopted patent systems in the 19th century. And some of those countries like China and Germany continue to have those elements, and we're now offshoring to those countries the innovation that we used to produce in this country. And so it's concerning.
I think we had a question right back here.
Yes, thank you. I'm an independent inventor, and I have been blessed to have had several families of patents that have been very good commercial success globally, but I'm still broke. And I tell my kids, to make $1 million in patents, you have to invest 10. So I very much share your story, Josh. Thank you for sharing it again. I saw it on Invalidated. That's not the right movie to show your wife on a Saturday night because it was very impactful. But one of the comments that I'd like to see in terms of maybe answering how we can help the system is, one is the issuance of patents, and two is the enforcement of patents. And if we can shorten the time that it takes for us to get patents from 2 to 3 years on a patent to 2 to 3 months. By investing more into the patent office review, I understand that each examiner maybe spends 19, 20 hours on a patent. Well, if we could have them spend those hours within a week or 2 weeks instead of 2 to 3 years, then the burden on the patent owner can be, and the inventor can be less. And so therefore, if I have an idea and a patent and I know within 3 months that it's not going to work, then I haven't really invested that much time and effort and research and development. And I just wanted to see what you thought of that idea.
3 months is aggressive. You know, the Track 1 program is, I think it's one of the, I mean, I think I would call it a success. They're pretty close to 12 months from filing, within 12 months, pretty consistently. That's a pretty big improvement over the 3-year average. You have that. There's something I often think about. It's similar. It kind of bridges this gap between issuance and enforcement. The AIA, the American Invents Act, did have a third-party disclosure provision, and it's just not used. And I don't see why these tech companies aren't using their vast computing resources and artificial intelligence to monitor these applications, file this prior art during prosecution, get it in front of the examiner, and then at least you know at the end whether you've got a valid patent or not. They have the capability to do that, I believe. It's just they'd rather save that and assert it to invalidate your patent after it issues. That's something I've thought about a lot, is to use the third-party filings more robustly.
I come at the IP issue from the perspective of U.S. embassies operating overseas. And I just want to ask, it's been said a couple of times that in case of Europe and maybe even in China, there may be more patent protection against infringement than there is here. If any of you could comment on what would be the 2 or 3 things that a foreign government that did want to do the right thing to protect against infringement, what could they do either legislatively or enforcement? Thank you.
I think that tees you up perfectly, Adam.
So the key features that economists and historians have recognized were essential aspects of the U.S. patent system as a key driver of the U.S. innovation economy, especially in the 19th century, was recognizing that these are property rights. So, and what that means is that they're tradable assets in the marketplace. So you can embrace the specialization, division of labor, inventors can invent, they can turn to venture capitalists or business persons to innovate. So Samuel Morse can transfer his patent to Amos Kendall to set up the American Magnetic Telephone Company. Edison can transfer his patents to General Electric. Goodyear can transfer all of his license all of his patents and never manufacture anything to other people. But to have that licensing and trading work in the marketplace, you have to have it backed as a property right with an injunction. You can't have free market exchanges without injunctions, and you have to allow for full damages upon infringement. And so these were key features that the U.S. patent system provided. We distinguished it from other systems. Particularly England. When we broke from England in 1776 and then put patents in our Constitution in 1787, patents were very much part of the American exceptionalism, and we actually took this unique approach at the time that we'll treat them like property rights. And it served as the foundation of a lot of economic activity, and they were enforceable in courts with injunctions, and they were adjudicated by disinterested judges operating under the rule of law. That was another key feature, is that patents, as part of being property rights, were treated like all other property rights, so that they were issued by stable political legal institutions that were operating under the rule of law, which exactly was not happening in England, where there were still prerogative grants by the Crown that were issued through massive administrative discretionary processes, so and adjudicated as such. So these are key features, I think, of any country that would want to set up a system. Of course, the patent system is not the only thing. You have to has to be embedded within a broader system of free market and things of that sort. But these are the features that China has adopted for its patent system. You can get an injunction in China. You can get full damages in China. You can license your patents in China. They have recognized that these are the features that drove the U.S. innovation economy, and they recognize that if they want to have an innovation economy, that this is something that they've implemented as well.
I think there's a question in the back.
Thank you. Build on Bill's question about how much worse it can get, because I always like to look at the negative side of things. Mention was made of the 40th anniversary of the Bayh-Dole Act, and we are now seeing proposals in Congress and elsewhere to, for example, exercise compulsory licenses, to exercise march-in rights, to impose price controls under Bayh-Dole. And I'm wondering how that will affect the work being done in our universities and their ability to transfer that technology to startups and create those new jobs and new technologies. I know you have some great stuff going on at SUNY Downstate, just to give a shout out to Kings County. Thank you.
I'm not sure if I heard the complete question, but I think you were discussing march-in rights as it relates to Bayh-Dole. I'm trying to think the last time that I've heard or read about the federal government utilizing its march-in rights to go sweep in and give rights to a federally supported technology, and I think those circumstances are rare. We are cognizant of that, especially as it relates, as we move more towards a model where we are spinning our intellectual property into startup companies that are, of course, cash poor. That is a risk that I think we make them, we kind of explain that to them, that that's a possibility, but historically we've been relying on the fact that that's a rare occurrence.
Yeah, I think the question is, going forward, the proposal is now to employ market rights or other compulsory licenses as a means to effect government price controls on those products when they are commercialized. How that might affect your pipeline.
Yeah. I don't think it hasn't affected it yet. I don't think that it will affect it in the future. But it's something that we would have to, of course, be cognizant of and possibly modify our practices.
My understanding, not from the U.S., but the only example I've seen similar to this was in Brazil, where the government was threatening a compulsory license to a U.S. pharmaceutical company. And it was basically doing it as sort of to coerce them to lower their price. The U.S. company said, we're not going to go there, fine, compulsory license. The Brazilian government issued the compulsory license, ended up getting an Indian company to supply the medicine. In the long run, they paid more than they would have had to pay if they had just agreed to the price that the U.S. company wanted. So it actually rebounded the other way. They ended up getting lower quality and higher price than they would have gotten originally. So it's a very little known fact out there, but that is when one of the times that a compulsory license has been issued, and that was the effect. So given that example, I would think we would not want to be encouraging that, because it would have the opposite effect, but not a lot of people know that example.
Okay, I think we had a hand up over here first. Herb? Oh, sorry.
I was wondering if any of you have any thoughts about how to address the phenomenon of efficient infringement.
Well, go back to the previous standards where you could get an injunction. As I mentioned in our opening remarks, the practice of large companies saying, I'm well capitalized and I will drag you through a decade of litigation and you will not survive, so go away. That is not new. That's not a new practice at all, or at least a new attempt at trying to do that. I mean, a very famous example of this is when Polaroid had to sue Kodak in the 1970s for infringing Edwin Land's famous innovations on one-step photography. By the way, yesterday was the anniversary of 1948 of the patent issuing on his one-step photography invention. And in 1978, Polaroid had to sue Kodak because Kodak they had the internal documents. They said, we're just ignore their patents. We need to compete with them. And Kodak was the multi-billion-dollar, had I think 80 or 90% of the film market at that time, and it took 10 years. And by the way, they were selling their infringing product, and they argued, well, if you allow the injunction, all of our employees will be put out of work, and all of these people will have cameras that won't be supported anymore. And the court said, well, that was a business decision you made, Kodak, in 1974 when you chose to infringe. You can't use now it's the classic, please don't throw me in prison. I'm an orphan now because I killed my parents, right? So Polaroid not only got an injunction, a permanent injunction, they got $1 billion damage award. $1 billion damage award in 1986. And that was upheld on appeal. It wasn't cut by 50% or 70%. And so this was a time when property rights were respected. And you had companies, you could have a smaller, relatively speaking, a smaller company like Polaroid. Edwin Land, was a great inventor of polarization technology itself. That's where Polaroid comes from. Could really drive innovation and new technology and consumer benefits. And Edwin Land understood the patent system too. He was giving speeches in the 1950s about the importance of patents, and because Polaroid had a very deep R&D based business model. The solution is to allow for injunctions again and allow for proper damages. So that it's no longer an economically viable decision for a company to say, we can just infringe because it's cheaper for us to do so.
Okay, I think we have time for another one. I think, Herb, you had your hand up first, so let's come up here if we can.
Well, this is a question for Professor Mossoff or anyone. Adam, when you were talking about efficient infringement, you alluded to the many academic studies that support a correlation between property rights and innovation. Now, as we know, not all inventions are the same. Some inventions are breakthroughs, blockbusters, disruptors, kind of inventions made by Thomas Edison. It's his birthday today, by the way, if you don't know that. So my question is, these many academic studies supporting property rights, innovation, correlation, do any of them support that the blockbuster inventions are more likely to come from small inventors, startups, and universities? And if there is any support for that, should we be taking that into account when we talk about how the patent system should be reshaped in the future?
It's a great question, Herb. And the historian who's actually looked at this, Zarina Khan, has found that the majority of the great American innovators in the 19th century were obviously individuals, but out-of-the-box innovators. So people who were not working within the industry in which they were typically working were either working as a sole independent inventor or working in a small company, and that they ended up having the challenge and take on very large companies. And also this correlates with other studies that are done by the Department of Commerce and others that find that, of course, small companies, SMEs are the primary driver of economic growth and new jobs in this country. And so you can put the two together. Patents are primarily come from the patents that are really valuable come from the individual inventors and the small companies, Josh and others, who come up with these incredible innovations, and then their companies become successful on the basis of their property rights, that they were able to get venture capital funding and financing and engage in licensing and other commercial transactions that drive economic activity. And so that then serves as the basis that this is what drives the economy.
But I would say incremental innovation is just as important. I mean, that's, I think the whole patent system is premised on that, because that's why you're supposed to publish your information, is so that others can actually see and then build upon that. And, you know, there are many other companies where the incremental innovation, you know, like the typical incremental innovation in a pharmaceutical company is, you know, you go from taking it 3 times a day to once a day.
Yeah.
And that's, you know, that's an important thing if you're a patient.
I don't mean to diminish incremental innovation. It's very important as well, yes.
Our next very distinguished speaker is here, so please join me in thanking our panelists today. Thanks, guys.
Well, good morning and welcome, everybody. And what a terrific panel Lisa led. So thank you to our first speakers. My name is Holly Fechner, and I'm a partner here at Covington & Burling. And we're so pleased that you were able to join us for our conference today to talk about the importance of intellectual property, both to our economic security and national security. Our next speaker, and we're honored to have him, plays a central role in ensuring that our patent system stays strong and vibrant. As chairman of the House Subcommittee on Courts, Intellectual Property, and the Internet, Congressman Hank Johnson leads the panel with oversight of all important intellectual property issues, including focusing on oversight of the USPTO, all patent legislation, including the Stronger Patents Act. Chairman Johnson, I think if there's one thing that really defines his career, is its access to justice. He has focused so many of his efforts over his career on ensuring that there is access to justice for people in this country. He is a leader on intellectual property and consumer issues. Just this past June, his subcommittee held a hearing on the spike in fraudulent trademark applications, particularly in China. And Chairman Johnson is committed to introducing legislation to address that issue this spring. At the same hearing, he examined the prevalence of counterfeit goods that are sold online. And that is another subcommittee priority that we look forward to him working on. And Chairman Johnson is also a leader on one of the issues that I think is most important for the system, which is ensuring diversity and inclusion in inventing and patenting. Last Congress, he co-sponsored the Success Act, which both approved the USPTO's fee-setting authority, but it also required the USPTO to do a study on diversity in patenting. It was a very successful study, and the USPTO is continuing its efforts in that area, as is Chairman Johnson, because he is now a co-sponsor of the IDEA Act. And the purpose of this new bill is to ensure that the USPTO has the ability to collect the needed data to better understand patent gaps and to fix them. Now, in his 7th term as the representative for Georgia's 4th Congressional District, Chairman Johnson previously worked as a criminal defense attorney and served for 12 years as a magistrate judge. So please join me in welcoming Chairman Hank Johnson.
Good morning, and thank you, Holly, for that kind introduction. And I want to thank you all for inviting me to speak to you today. As chairman of the House of Representatives Subcommittee that has jurisdiction over the patent system, I think that the title of today's program has it exactly right when it links the patent system to promoting job creation, competitiveness, and national security. The details of how the patent system is best optimized to achieve these goals can be highly technical and nuanced, but the reason we have to engage in these debates and discussions is simple. Innovation is the key to the future, and patents are a bedrock mechanism of how we incentivize innovation in this country. We are fortunate at this point in American history to have a heritage that includes a culture that lauds the garage inventor, the person with a great idea who goes on to create a multi-billion-dollar company, maybe creating a new industry sector along the way. It's easy to think that the machine of our innovation economy will keep cranking out such winners. But this machine only runs because our country and our economy have long provided key inputs: an educated workforce, the rule of law, and even freedom of speech that creates an environment hospitable to letting people pursue ideas that may seem unorthodox at the time. The patent system is one of these key inputs, but as those in this room are no doubt aware, the patent system has undergone a series of changes over the past decade and a half, which raises the question, when you tinker with the inputs of our innovation engine, what impact do you have on the output? I remember, for example, 2 years ago, the surprise when the U.S. Chamber's International IP Index, which ranks the strength of different patent systems around the world, put the U.S. patent system at 12th place. Of course, we rebounded last year back up to second place, where we remain this year, according to the latest report that came out last week. I'm pleased to see the turnaround, but I am concerned about how lasting this recovery might be. This is because the report itself gives an explanation for its assessment of the strength or weaknesses of the patent system in question. For the U.S., the report lists 4 key areas of strength. 2 of these 4 relate to administrative changes made by USPTO Director Andrei Iancu, specifically Director Iancu's changes to the procedures of the post-grant proceedings at the Patent Trial and Appeal Board, and his guidance on assessing patent-eligible subject matter under Section 101. Director Iancu, who will be speaking next at this conference, should be applauded for his service and stewardship of the patent system. But we all know that these kinds of administrative changes are not the same as making changes to the law. As a member of Congress, I will readily admit that changing the law is not easy. But in this instance, that is the point. If the perceived strength of the U.S. patent system can fluctuate dramatically based on administrative changes alone, it is reasonable to question whether the law needs to be changed to decrease the degree of regulatory authority delegated to the executive branch. In other words, we have to take a step back and ask whether this is how we want our patent system to work. If patents are meant to be the stable basis on which research and development investments are made, what is the impact of having this much change in the system possible without a change to the actual patent laws? I think this is a question we must start to examine in earnest. While the exact design of patent trial and appeal board procedures has been the subject of scrutiny since the proceedings first started nearly 8 years ago, there is now a more recent and acute challenge to these proceedings. I'm speaking, of course, about the Federal Circuit's decision in Arthrex versus Smith and Nephew, which concluded that the administrative judges on the Patent Trial and Appeal Board were performing duties in conflict with the requirements of the Appointments Clause of the Constitution. Our subcommittee's last hearing was on this decision and its implications. The administrative law and patent law experts who were on the panel were unanimous in their support for legislation to address the uncertainty created by this decision. For my part, I made clear that I have concerns with the remedy that the Arthrex Court identified for fixing this constitutional problem, namely making administrative patent judges at-will employees instead of having civil service protections. This is a setup that is prone to due process concerns because it incentivizes administrative patent judges to adjudicate with an eye towards preserving their livelihood. If the Appointments Clause requires that a presidentially appointed Senate-confirmed officer have the last word in these cases, that power should be exercised transparently rather than through the ever-present threat of losing one's job. At the end of the day, I recognize that courts may be constrained in trying to fix the constitutional problem they have identified. Congress is not so constrained, and so I consider it a priority to consider legislative alternatives. In doing so, I think it's worth looking at other models in the administrative state, such as independent commissions, that attempt to balance the need to have politically appointed officers responsible for decisions with creating a process that preserves hallmarks of adjudication by guaranteeing the neutral application of laws to facts. In any case, the bottom line is that Arthrex will continue to generate uncertainty about the fate of the Patent Trial and Appeal Board unless and until this case reaches the Supreme Court. And whatever outcome that will produce, it is likely that the best solution is for Congress to fix the issue itself, or at least try to fix the issue, and eliminate uncertainty about the legality of these proceedings. While I've spoken now at length about how the Patent Trial and Appeal Board is affecting our standing in the U.S. Chamber's IP Index, it is not the only factor that concerns me with respect to ensuring the long-term competitiveness of the U.S. innovation economy. As I alluded to before, there are many inputs to the U.S. innovation machine. Another key input is our human capital in this country. I have been concerned that we as a country are not empowering the full range of our residents who might have innovative ideas. We had a hearing last year about the lack of diversity in who is obtaining patents in this country. It's clear that we are leaving talent on the table, something we cannot afford to do if we are to remain competitive. A related concern that came out of this hearing is the issue of IP awareness. In other words, if you come up with a great idea, do you know enough to consider pursuing patent protection on that idea? To those in this room familiar with intellectual property, that might seem far too basic a question. But you only need to look at newspaper articles from otherwise informed journalists who frequently confuse patents with trademarks and copyrights. The lesson I learned from our first hearing on diversity is that you cannot take for granted that highly educated people in society and engineering are learning about the patent system and when they should engage with it. In contrast, I think it's worth noting that some of our major competitors are taking a more proactive stance to educate their citizens about intellectual property. In China, for instance, there has been a change in recent years to add questions about intellectual property to the test students take for admission to college. These aren't throwaway questions either. One question in 2019 asked, for example, why innovation should be protected by patents and why the term of patent protection should not be indefinite. Another question asked why the protection of intellectual property should include both legislation and enforcement. These are sophisticated questions that require college-bound students to both be aware of intellectual property and to understand its greater role in society. In our country, in contrast, I'm not aware of large-scale systematic efforts to promote IP education and awareness. There are certainly many great one-off and local initiatives, for example, the Girl Scout IP patch. In my home state of Georgia, there are also many local examples of highly motivated professors or individuals who seek to educate innovators and pair up scientists and engineers with lawyers and business people. I hope to explore these efforts with a field hearing in Atlanta later this year. We don't need to necessarily have IP questions on our college entrance exams, but I think it's worth considering what we can do to make IP education more widespread and less dependent on the presence of a few individuals in different communities to take this issue on themselves. After all, this matters not only to the individuals with great ideas who might be better positioned to start a small business if they protect their ideas with a patent, but it matters to all of us. We need to keep our innovation engine strong and healthy by providing it with the best possible inputs. This is the key to ensuring the continued creation of high-paying jobs, as well as American competitiveness and national security. As long as I am chairman of the subcommittee with jurisdiction over critical input, our patent system, I hope to do my part to ensure that it is optimized to propel us forward into the rest of this century and beyond. And I thank you for listening and have a great conference. Thank you.
If I could have everyone's attention, if you could take your seats, and we will introduce our keynote speaker. Okay, so I'm going to do the introduction for our guest of honor, and then he'll make some brief remarks, and then we'll open it up to Q&A. Good afternoon. My name is Laurie Self, and I am Senior Vice President and Counsel for Government Affairs at Qualcomm. We're thrilled to have everyone here for this conversation about the critical importance of intellectual property to U.S. leadership and global innovation, and how we can improve our patent system to achieve that goal. The exclusive right of inventors to profit from their ideas is the foundation of our innovation economy and a driving force behind American ingenuity and progress. Before I introduce our keynote speaker, I want to thank Chairman Johnson for his remarks this morning. Given that intellectual property rights are critical to the industries of the future, 5G, Internet of Things, artificial intelligence, inventors and patent owners need champions like Chairman Johnson and our next speaker. We're honored to hear from a leader who understands the importance of strong IP rights. Andrei Iancu is the Undersecretary of Commerce for Intellectual Property and the Director of the U.S. Patent and Trademark Office. Since his confirmation in 2017, Director Iancu has taken swift and decisive actions to strengthen our patent system. As Secretary Ross noted, Director Iancu has used his platform to provide more predictability in our patent system so that businesses can grow and invest with confidence. Under Director Iancu's leadership, the USPTO finalized a rulemaking that harmonizes the claim construction standard at the PTAB with the Phillips standard used in federal court. It initiated a process to make it easier for patent owners to amend claims before the PTAB and drafted new guidance to help examiners and patent applicants navigate the difficult terrain of Section 101. Most recently, USPTO issued an important joint policy statement with the Department of Justice and the National Institute of Standards and Technology to affirm the importance and availability of injunctive relief as a remedy for infringement of standard essential patents. I also want to commend Director Iancu for his commitment to fostering diversity in our patent system. Under his leadership, the USPTO has issued 2 reports highlighting significant underrepresentation of women, people of color, and others in the innovation process, including a finding that just 12% of U.S. inventors who were awarded a patent in 2016 were women. We thank Director Iancu for undertaking this important study and his commitment to ensuring that the U.S. does better to ensure underrepresented populations participate fully in our innovation pipeline. Director Iancu joined the USPTO from the Los Angeles law firm of Arell & Manella, where he served as managing partner. As an IP litigator, Director Iancu represented clients across industries and scientific disciplines, including medical devices, genetic testing, internet, telecom, and video games in high-profile matters before the PTO, district courts, the Federal Circuit, and the International Trade Commission. He has also taught patent law at his alma mater, UCLA School of Law. Thank you, Director Iancu, for being here today. And so I will.
Thank you, Lori. And by the way, do we have a hand mic I could use so I can walk around? Could I have one? Yeah, that would be great. And okay, so good to be with all of you and among so many good friends. I've been at this event at least I think a couple of times now, and I've just celebrated. Great. 2 years at the PTO, and it's been quite a remarkable journey for me. It's been an amazing experience, and first and foremost, obviously working with folks at the PTO, but really working with all of you, and with members of industry and of the bar. Such an amazing collection of IP knowledge, and together I think we've made tremendous progress, and I think we can do a lot more. Last year, so I want to spend just a couple of minutes saying a few words and then really open it up to discussion and have a robust discussion on anything that's on your mind. So get your questions ready. So last year was another remarkable year in the world of IP. So I was going to read to you a few statistics. In 2019, we received over 667,000 patent applications. This is the most patent applications ever received. 5% increase over fiscal year 2018. And by the way, this is about a 37% increase over 2010. So it's a reflection of a variety of things, but importantly, patent applications as well as trademark applications do reflect the state of the economy, and a growing economy will naturally have more patent applications. Importantly, we issued over 370,000 applications in 2019, and this is the most number of patents issued by the USPTO in a given year ever. And it's a 9% increase over the number of patents we issued in 2018. Obviously, the country that files the most and receives the most patents is the United States, no question about that. Second is Japan. Japan has, of all the non-US countries that file at the USPTO, is by far the leader, and they have been for a long time, by quite a distance. But now, in second place, for the first time ever, is China. They have had quite a bit of growth in the number of patent applications, and as a result, they have leaped into the second place. Quite a bit behind Japan anyway. So, for example, Japan in 2019 had 64,000 applications at the USPTO, almost 10% of total applications at the PTO. China in second place with 28,000. Korea and Germany follow. But it's interesting to see the rise of Chinese applications. It's not unexpected. The increase in 2019 was 14.4%. in applications from China. Korea is also improving quite a bit. They are up 9.6%. U.S.-based entities account for about half of all filings. That's been true for quite some time. And we expect that that trend will continue, although as the world becomes more and more aware of IP, we probably will see an increase in foreign applications overall. while we process the most applications ever, our pendency has gone down. So our total pendency now is at about 24 months, and our first office action pendency is down to below 15 months. This is among the big offices in the world, in my view, collectively the best in terms of pendency. Our appeal pendency is also down. Ex parte appeals down to about 15 months, and our goal is to get ex parte appeals within the next year to 12 months. No other jurisdiction of our size has anything close to these types of numbers. So those are just the numbers. You probably have seen the results from the U.S. Chamber of Commerce study that was released just last week. The 2020 GIPC study, they rank 53 IP jurisdictions around the world. The United States continues to be in the first spot overall, but our numbers have increased, and the distance between us and the rest of the countries has also widened, which is very good to see. Many of the areas have seen improvement. On the trademark side, for example, we have now moved into the first place on trademarks, tied with the UK, and a perfect score of 100 points. On the patent side, we remain in second place. You might remember that 2 years ago we were in the 12th spot. Last year we moved into second place, an 11-way, I believe, 11-way tie. This year we are still in second place, but it's only a 4-way tie. So these 4 countries, us and the other 3, have increased the number of points overall. So we distanced ourselves from the rest of the pack. Singapore continues to be the number 1 jurisdiction in this study when it comes to patents. We are also number 1 in a number of other IP areas, copyrights, for example, and the like, and we perform quite well in a variety of other areas as well. So the cumulative score is what I mentioned. We're in the first place, and it's really good to see. It's a reflection of the overall commitment of the United States to strong intellectual property rights. Back to patents, which I'm sure a lot of you care a lot about. As I said, we remain in second place, but with an improved score, and they do credit the work we have done at the PTAB, as well as when it comes to Section 101. But for us to move even further up, they do identify a key provision that needs to improve, and it's no secret, everybody knows what it is, which is still Section 101. But it's no longer the PTO's issue or the administration's issue. This is something that now it's up to the courts or the legislature to fix, because we have done what I think is the most we can do given the state of the law on Section 101. And I'm quite hopeful that something can happen when it comes to Section 101. It remains the most important issue to be resolved in the U.S. patent system. And the sad part is, in my view, is that it doesn't have to be that way. We know what the real answer, we know how to do it. We know the answer. It's staring everybody right in the face. And all that folks need to do is to take a look at what we have done at the PTO. It doesn't have to be, the courts don't have to follow it identically. The legislature doesn't have to follow it identically. But at least the framework works. And it's also a framework that's used, generally speaking, by all the other major jurisdictions. We know it works at the PTO. I hear it anecdotally from all of you, although if folks here want to talk about it, we'd love to hear from you as well today. We know it works based on what our examiners tell us, and we know statistically, we have the numbers. The number of 101 cases, the number of cases with 101 rejections in the critical areas, such as artificial intelligence, is down dramatically. The consistency of results, and we're going to look to publish a study on this area, the consistency of results between examiners in a particular area has improved dramatically to pre-Alice levels, and in fact better than we were back before even Alice. Because now we have clear guidelines and the examiners know what to look for and the applicants know what, how the analysis will be done. So it is more predictable. And if we could just have the courts, they obviously are not bound by our guidelines, but having a similar approach, which makes sense and is consistent with the case law, that would solve the issue. And as I've said before, I do believe the Federal Circuit is in a position to address this issue. And we have seen that the Supreme Court, just last month, denied cert in all the 101 cases pending before them. The legislature, there was some movement last year. We haven't seen very much since. But if industry would be able to create some consensus, I think there is an appetite on Capitol Hill to get something done. We obviously at the PTO stand ready to assist as needed. Other than that, there are lots and lots of other things going on. Lori mentioned standard essential patents. There is an election that's going on at WIPO that we are working on. There's lots of stuff still happening at the PTAB that we are working on. But I will leave all this for your wise questions, which I'm sure will be forthcoming.
Okay, so I will open up the questioning and then invite others to raise their questions. So thank you very much for your remarks. And thank you for all that you've done in your role as director to, I think, from our perspective, restore balance and strength to the patent system. You mentioned that the 101 issue really is now in the hands of Congress and the imperative to achieve legislation on that issue. I wanted to get your thoughts on legislation that would potentially codify the changes that you've made to the PTAB system. I mentioned the harmonization of claim construction, the right to amend. There are numerous other areas that the Stronger Patents Act addresses that, in the view of many in this audience at least, would restore balance to that system. What's your view on the need for legislation in that space, and from your perspective, what do you think are the most important aspects of a potential legislation on that issue?
Right, so I think the changes that we have done are correct. So if Congress wants to legislate and create statutes surrounding some of them, obviously I think that would be something that we would welcome. Some of the things that could be legislated do include what you have mentioned, for example, the claim construction standard. I think folks now, we've had about a year worth of experience. I think folks see that it's the right balance, and hopefully their consensus can be built surrounding that. There is a right to amendment already. That's in the statute. So the question is, should our approach be codified? Well, remember, with respect to amendments, we're still in a pilot program because it takes, at least a year for these IPRs to mature to a final written decision. So we'll see how that goes. We'll know more in a few months. But so far, it's looking really good, and it's an important improvement in my view. So if Congress wants to legislate on a similar approach, that would be fine. If they want to legislate on something else, we would need to see what that is. But having certainty that there is a viable amendment system that is not just there in name, but is actually viable, that patent owners can have a meaningful opportunity to amend, and making sure that that is a long-lasting provision, I think that is important. Other things that we have done, for example, that could potentially be legislated, but again, that's up to Congress, would be the question of serial petitions. We don't allow serial petitions anymore in most cases. And then there is the question of parallel petitions, that is the same entity or a related entity filing multiple petitions at about the same time against the patent. we basically don't allow that anymore either, absent some meaningful explanation. For example, an applicant might argue that, you know, a patent has 1,000 claims or a huge number of claims that they need to address with more pages, things like that. But generally speaking, you know, we have taken a narrower view on that. That's something else that obviously, if there's a will, Congress could address. Those are the major things. There are obviously a few other things that we have done. Whether, you know, look, they are there now. This is the way we're handling them, and we keep developing it. You know, with more cases that we see on these issues, you get more development. Can they be changed if new leadership comes at the PTO? Theoretically, that's possible. So, but I would hope not. I would hope if, even in the absence of legislation, folks would understand the benefit of the balanced approach that we have, and any change would not be so easy to accomplish. Obviously, a statute would be even more difficult to overcome. So.
I had the benefit of being with Secretary Ross in Iowa last week, and I told him that I would take the opportunity to say this directly to you, as I was one of your cheerleaders in Iowa. The great baseball legend Satchel Paige had a saying. He said, you know, it's damn difficult to steal second base if you want to keep one foot on first. And that meant that you had to have a certain risk orientation. You have been a champion. You haven't been afraid to disrupt the status quo like a couple other folks in D.C. that I know. And I think it really does behoove us to be your champions, to be your fans, to encourage you, to not only to create that human capital and the opportunity that's necessary to convert us from a fastly developing welfare state to an opportunity society. And what you're doing in terms of opening the playing field for women and people of color is important. But more importantly is your attitude of not accepting a stale status quo. And I just wanted to take the opportunity to say thank you.
Well, thank you very much. I very much appreciate that. First of all, Secretary Ross is a big supporter of IP, has a natural inclination towards these issues, and he's been a great supporter of everything we've done in the past couple of years. In terms of taking risks on policy issues, look, that's why we're here. I don't very much understand the concept that we're being sent here by the people, entrusted with this great privilege for a limited period of time, and not do what we think is the right thing to do. So we try to do things, and we do what we think is right after consultations with the public. Sometimes the court won't agree with what we do. That's okay. If they don't agree, they'll tell us. You know, there'll be an opinion, and they'll tell us if they think it's wrong, and then we'll adjust, or the public can tell us. But I think you're right. We need to try to do to be bold and do what folks think is the right thing to do. You mentioned expanding opportunity to people of color, so let me take this opportunity to address that briefly. I don't know that overall, there are lots of important things that need to happen in the world of innovation and IP, but I don't know that there is something more important if you look globally at the United States from 30,000-foot level than to expand the innovation ecosystem demographically and geographically in the United States. The United States competes in the worldwide stage. You know, I used to say that we compete with one hand tied behind our backs. I now, especially in light of the recent studies that I've now amended my statement. We compete with one hand and 3 or 4 fingers tied behind our backs. So innovation in the United States is very concentrated geographically. It's only in certain geographic pockets around the country. And then within those pockets, it's concentrated demographically. Only 12% are women, lower numbers, although we don't have the actual numbers of the PTO because we cannot collect that data, but others have lower numbers still, single digits for racial minorities. Folks from economically underprivileged communities that don't go to the more economically privileged schools, they don't innovate nearly at the same rates. So you combine all of that, you have a very small subset of human beings in the United States who are engaged in the system. Well, boy, it's difficult. Maybe that worked well, and it did work for the past couple of hundred years. But now, but it didn't work for the people who are not engaged. Number one, and then for the United States now, the whole world is innovating, and some of them are really focused on this. So difficult to compete with 1.4 billion people, for example. We're not going to compete with them on the on the population size. But what we can do is increase the percentage of the folks that we do have to participate in the innovation ecosystem. So to me, this is like the #1 priority, and the rewards would be tremendous. It's you know the potential is phenomenal. First, for the individuals, all sorts of studies show that people employed in IP-intensive industries make approximately 50% higher wages, plus all the the opportunity to advance, the job satisfaction and all that. So for the individual, tremendous advantage. For the various companies and small businesses to get more people participating. And then for the United States overall, the potential is tremendous. A Harvard study showed that if we increase participation from all these groups, innovation in the United States could quadruple. Well, imagine that. So it's a huge issue. Everything else we talk about is also important, obviously. Section 101, PTAB, all that. But those are tools that feed into the ultimate goal of increasing innovation in the United States. Thank you. Bob.
Hi, Director. I want to change the topic a little bit to quality. I recognize that quality is a shared responsibility between the applicant and the office. I think it's really important. I think it drives a lot of the problems that we have right now in the system. And I want to know, I also believe that it's the search that really kind of sets out whether or not you're going to get a quality action out. What new initiatives are you thinking about to improve the quality even more? I think it has definitely improved over the years, but it's always an iterative process where we need to continue to improve it. And I want to know if you've been thinking about any new ideas to improve the quality of patents that come out of the Patent and Trademark Office.
Yeah, thanks, Bob. I agree with everything you've said, including the fact that, yes, don't quote me on that. Including the fact that the #1 source, the #1 area where we can make the biggest difference is on the search. So I'll talk a little bit about some of the initiatives, but we should not forget that the quality of the application coming in is critically important. So that also needs to improve. Tiny thing, which is not most likely popular with the bar, is that we are asking the patent bar to voluntarily take MCLE courses and certify to us that they have on a voluntary basis. It's not going to make a huge difference, but at least it's something to get going in that direction. There are other people who say that applications should be graded as they come in, and then on various criteria. And then if it doesn't meet the minimum level, we send it back, kind of like a missing parts kind of thing, to help improve the incoming application. I've heard other folks saying that we should grade the applications, and then over time each lawyer develops a GPA, and we can post that for the public to see. But I don't know, those are not necessarily serious considerations. The real big difference will be in the search. The examiners can examine. Obviously, we can always train them, and we do train them to examine better. But they can't examine against prior art that's not before them. So the prior art of the relevant prior art needs to get before them. So I've been talking for the past 2 years about improving the search. And I'll give you an example of one small initiative that we're testing out in a pilot system, which is that 2 examiners can check each other's search independently. So the main examiner on an application, they do their own search, but now another examiner paired with the first one will do the search as well, and then they check against each other and see how they fared. That's working pretty well, but we're doing that on a very small scale. Obviously, it would be a significant cost impact if you do it on a large scale. In the end, the answer here is extra automated tools, artificial intelligence tools. It's basically impossible for a human being because you always will have 1 or whatever, 2 human beings vis-a-vis one application. The amount of art that's out there is growing exponentially, it doesn't stop, and it's almost impossible for any human being to keep up with all that. So automated tools are critically important. We have all sorts of automation going on, but we have a huge project on AI. And to me, that's the ultimate answer. The AI will never will never do a perfect search. So the examiner is always going to be needed. But if the AI can be used to narrow the field and present a superset of prior art references to the examiner to search within and then analyze within, I think that would be a great help. Lisa.
Director, thank you for being here. Recently, sort of thinking about the search issues, the USPTO and IMPI, the Mexican Patent Office, signed an agreement for patent applications that will come from the U.S. into Mexico and the work-sharing program. Can you share that with us, and do you see this as a trend to have these bilateral type agreements?
Yes, thank you. We had 2 weeks ago, Secretary Ross and I went to Mexico City, and we had a signing ceremony with my counterpart, Director Lozano of IMPI, and Secretary's counterpart, the Secretary of Economy. And it was an amazing ceremony. And it was all surrounding the signing of this Memorandum of Understanding. The first time the United States did something like this. It's basically going to be a parallel grant procedure. So, once an applicant gets a patent allowed by the USPTO, that applicant can share that information with the Mexican Patent Office and request a parallel grant from the Mexican Patent Office. And Mexico, as a result, will check the formalities to make sure the patent is compliant with Mexican law, but will promptly issue a parallel Mexican patent, and we're hoping that that's going to be within 2 or 3 months of the request made by the applicant. And that is absolutely phenomenal. 2 or 3 months. The current pendency in Mexico is almost 5 years. And you have to go through the whole rigmarole all over again. So this is going to be almost a 2-for-1 for U.S. applicants. And the answer to, and we're very excited about it. Mexico is super excited about it. They had, it was a big stage where we signed this, and there were many speakers, including a Mexican senator, the head of AmCham in Mexico, the head of the Mexican Chamber of Commerce as well. Many people spoke, as well as myself and Secretary Ross and the like. Anyway, so behind us, there was this big, big sign that said, "Más patentes, más rápido." So they were very excited about being able to issue more patents quicker. And to your second question, yes, we are hoping to be able to do this with other countries as well. I think it's a huge win-win for everybody, huge benefit for U.S. Applicants that can get faster proceedings in other jurisdictions. Great benefit for the other countries as well. Attracts more business to their country, relieves some of the pressure from their patent offices as well. So we're hoping to be able to do others like it.
Richard?
Congratulations on the second anniversary. You've spoken about the importance of consistency for the patent system. If President Trump wins in November, would you like to stay on in the second term?
Who has the next question, Laurie? Yeah, look, I serve at the pleasure of the president, obviously, and I'll serve as long as he wants me to serve. And it's been a great honor to be here. Obviously, anything can happen going forward, just like with anything else in government. But I very much enjoy this opportunity. I think it's been very rewarding for me to have the opportunity to help the system a little bit, and I look forward to continuing.
We sincerely hope you'll stay. Put that plug in.
Thank you.
Go ahead.
Thank you. Some of the panelists before you were here talked about a problem called efficient infringement, where large companies have sufficient resources to litigate to get access to somebody else's IP. And they pegged it really to two problems. It's very hard to get an injunction to stop the infringement. And at the end of the day, it's very hard to get enough in damages to really make it not worthwhile for the large company to take your IP. How would you react to that? Do you think there's any grounds for those complaints? Thank you.
Yeah, look, until 2 years ago, I was a litigator, and I represented clients of all sizes and types on both sides of the V. So I'm very familiar with the issue. Patent litigation in the United States has never been easy, never, and it probably never will, because for many reasons. But there's a lot at stake in any of these discussions, and sometimes the nuances are very, very, subtle between the patent and the accused product, or the patent and the prior art, and the like. Plus, the issues are very complicated. So, patent litigation in the United States, and also its litigation in the United States, which by itself is complex with our discovery rules and the like. So, all in, it usually takes quite some time. It usually is expensive. And the results are uncertain sometimes. And that, I don't think, is unusual. I like to give the example of the Wright brothers. Their litigation against the Curtis company back in the 1910s and 20s took forever. And it basically killed Wilbur. He took it so hard it consumed him. That is compounded nowadays, as you say, by the uncertainty with injunctions, given the eBay case from a number of years ago. It's compounded by the uncertainty with Section 101 and what the Court of Appeals will do, for example, on that issue after the trial. And those are all issues that we need to keep in mind and try to improve. Having said all that, you look at the big picture. I don't think there is a better climate anywhere in the world as compared to the United States. I would much rather have our judicial system here and our system of laws, as complex as it is, than almost any other system in the world. I don't think it's even close for many reasons, including the fairness and the independence of the courts, including the fairness and independence of juries that our litigants are entitled to. Do we need to make some improvements? Certainly, as I said, on Section 101, and some other things. Should we be looking for ways to make things less complicated and less expensive? Sure. We should always keep working to improve the system, but I don't want us to lose sight of the fact that we still do have the best system in the world. And as I said, I don't think it's even a close call.
Okay, we have time for one last question. Yep, Kira.
So, you teased at the beginning in your introductory remarks that you were going to talk about the great chess game that is the WIPO DG race. So can you talk to us a little bit about that and sort of the counterintuitive strategies that sort of might be coming into play?
Sure. So you probably know at WIPO, the DG is elected every 6 years for a 6-year term. And the current term expires later this year, and we have an election coming up for the next DG. The way it works is that there are 170, I think, countries, members of WIPO, but there is a coordination committee, COCO for short, of 83 countries. And it's the coordination committee that is going to vote March 4th through 6th. And usually that drives the ultimate outcome. So the focus right now is on this coordination committee and how the 83 countries will vote. There are 8 candidates now. There used to be 10, but Estonia dropped out and Argentina dropped out recently. So now we have candidates from Japan, Singapore, China, Kazakhstan, Ghana, Nigeria, Colombia, and Peru. Have I left anyone out? I think that's it. I think that's 8. And there are lots and lots of discussions as to who is the right candidate and what the qualifications are and what geographic region they should be coming from. The United States and most of Western Europe and Australia, as well as Canada, we are part of what's called Group B. These are mostly the developed countries. The current director is from Australia, so that's Group B. So the thought is that it shouldn't be somebody from Group B. So it should be somebody from, the general thought around the world is it should be somebody from Latin America or Asia Pacific, maybe Africa, although Africa had it 2 terms ago. So those are the discussions. The election is in 3 weeks, and we'll see what happens. We think the candidate needs to be somebody who has experience, preferably in IP, preferably experience running an office, so managerial experience. Somebody who is enthusiastic and a great supporter of IP. Somebody who comes from a country that respects IP. And somebody that can create consensus around the world. Generally speaking, we have, the world is a big place and there are many different types of countries. It would be really good to be able to be in a position to bridge the various gaps that exist and create consensus between, geographically east and west, big countries and small countries, developed and developing countries. And there are several of the candidates that I've mentioned that satisfy these criteria, and there are some that don't. Thank you all. Great to be here with you, and hope to see you again soon.
Reading glasses on. Hey, buddy. All right, I was going to dump that stuff there. You mind? Hey, Rob, I think that one's mine. Oh. So you guys are... See, I did have it wrong. That was the only preference. Oh. Okay. I just need the...
DC next.
Thanks, everybody. I know people are transitioning from the last event, grabbing coffee, etc. But I think we'll get started on our last panel, intellectual property and national security. We've got a very distinguished group that I think can shed a lot of light on these complex issues that are at the forefront of much of what we're talking about today. We've got Rob Strayer, the Deputy Assistant Secretary of State for Cyber and International Communications Policy, Kellyanne Shaw, former Deputy Assistant to the President for International Economics, Nadia Shadlow, Senior Fellow at the Hudson Institute and also former Deputy NSA for Strategy, and Sue Armstrong, SVP for Engineering at Qualcomm. So the title of our panel, IP and National Security, really brings together something that has been a debate for a long time in big policy, and that's the intersection of economic security and national security. And sometimes there is a perspective that there is a choice to be made between these two. But I think it's becoming increasingly clear that these are, at the very least, sides of the same coin, and that you can't really have national security without economic security. So let me start maybe with you, Rob, about what's the sense inside the government now on how these two missions are met? In state, you consistently have to deal with both of these issues, but as you interface with the White House and the National Security Council and the National Economic Council, is this viewed of a piece? And I'll just leave it at that.
Yeah. Great. Thanks for that question, John, and thanks for including me on the panel. And I want to thank Brian, wherever he is, for organizing today and including this topic of the confluence of national security and economic security. And everyone in this room knows that the United States is a leader in innovation. And in part, it's been through our ability to protect intellectual property rights. And we've seen, of course, the digital economy drive tremendous amounts of economic growth around the world, improve people's lives. And particularly in the United States, we've benefited from that, but people around the world have also benefited from that. It's certainly clear that intellectual property is a key driver for all this growth. It will be the reason why we have the technologies of the future that we can't even envision fully today, including artificial intelligence. So we have to undertake a lot of effort to ensure that we keep intellectual property on the right track. So I think all of us in the government currently know that we have to work very hard to ensure that we're protecting both our economic security and our national security. In many ways, as Secretary Pompeo is fond of saying, our economic security is our national security. As we see this tremendous amount of growth, at least as estimated by some, 46 million U.S. jobs supported by intellectual property intensive sectors, as well as at least $6 trillion to the U.S. economy. We know that's also under assault by competitors out there who don't share our values, who do not respect intellectual property rights, and who seek to shift the playing field, to skew the playing field, to advance their national interests and disadvantage our companies. So it's very important that we have this agenda, this concerted agenda in government and with the private sector. There's three things I just want to highlight as overall policy objectives that I think we need to pay close attention to in the years ahead. The first would be with regard to standards. Intellectual property for the United States plays a very important role in standards around the world. We must continue to have global cooperation on achieving standards and standards that will be not driven by national interests, but that seek to enhance the best technologies of the time so that through competition we see the best of technologies going to the next generation of innovation. Unfortunately, we do see sometimes countries putting a thumb on that scale, seeking to advance their own national interest in standards-making bodies. We're going to ensure that we keep standing up with like-minded governments to have a coordinated approach around the world so that we're fully addressing those that would otherwise seek to have these standards bodies not based on the best of technology. We need to keep having what we've had for many years, which is a public-private partnership with government and the private sector one that includes the government, academia, and private sector partners that can facilitate the right types of R&D and not do it in a way that's going to select certain winners and losers in the process. The second area that I think we need to pay a lot of attention to is because some of these actors in the world do not have our values, our shared values in mind, we need to make sure that as we promote emerging technology, it's done so with the right kind of values, and that we are seeing outcomes of the technology that are advancing Western democratic values. One of the most recent examples of this that I think showcases what we can do is the United States and 40 other democracies joined together in the OECD to develop a set of artificial intelligence principles. Among those principles are that it should be based on fairness, democratic values, as well as having the explainability for AI and accountability for it. Those type of principles are ones that we can develop related to other emerging technology and ensure that the policy that follows from those principles also embodies our values. Lastly, I wanted to address the theft of intellectual property and forced technology transfers. It's been a way that China especially has sought to benefit its companies and disadvantage our companies. The U.S.-China Phase 1 trade deal made major steps forward in addressing requiring changes of China and other policies within their system to end intellectual property theft and forced technology transfer. We know there's more work to do on that front. We know that just as of yesterday, we heard that the PLA had been indicted for stealing half of Americans' financial data. We also know that we indicted Chinese actors a year ago, December, for what was probably the largest modern act of intellectual property theft in the Cloud Hopper set of attacks, where the Chinese Ministry of State Security copied entire databases of blue-chip companies, and in some cases provided that technology to their own companies to compete against the rest of the world. That's completely unacceptable. More than a dozen countries stood up against that at that time with the United States. We need to keep at that attribution, and then as well as move forward in imposing consequences on that type of intellectual property transfer that is cyber-enabled, that is benefiting the countries themselves. And this is not at all to be associated with the normal types of intelligence collection that countries do. We just say that kind of activity is completely unacceptable and will be met with swift, transparent, and costly consequences. We do this together. We can sustain our intellectual property model for the future, and it will benefit both the United States citizens and people around the world. Thank you.
Well, that's you've given us several panels worth to unpack here. But I'll start with your top line, your number one, and the role of standards. And Sue, in addition to standards, as the economic actor on the panel, we're talking about national security and economic security. From a corporate perspective, while you contribute to the national security capabilities of the United States, your responsibility really is dealing with these commercial interference. So based on some of the things that Rob talked about, and just from your own perspective at Qualcomm, what are the things in we as a nation thinking about how to protect intellectual property as a key component of our economic security? What are the incentives that we should be thinking about? What do you think about what the government is doing and how this entire environment is changing in?
So I would say, first of all, as everybody knows, you cannot have national security without technology leadership. And Rob talked about the standards. And you can't have technology leadership without a strong intellectual property system. The intellectual property system has caused American technology to thrive for 100 years or more. In my lifetime, in my career, it's been one of the primary causes of technology leadership that we've seen in communications, for example, in the whole digital sector, in creating, the first personal computers and the first mainframes, et cetera. So technology leadership goes without saying. And a big piece, for example, at Qualcomm, We do all the, we do a variety of things. We make semiconductors, huge amount of software, but we also do the fundamental research and development that goes on in these incredibly complex systems called communication systems. And generally, we are researching these systems and making inventions and investing in these systems 5 to 10 years before they ever start to be built into commercial products, and then the product cycle is about another 2 years. So it's often 6-10 years of investment before a company like Qualcomm sees any return on that investment. And without the patent system and without being able to license our patents, we would simply not be able to fund that level of R&D. These are incredibly complex systems, and they take a lot of funding, well ahead of commercialization. So that's my first point. Sometimes, people consider companies to be greedy companies who take that R&D money and it goes into somebody's pocket. But you also have to think about the fact that that R&D money that is invested from licensing of these innovations, that's jobs. That's jobs, and that's talent, and that's American jobs, and that's jobs like mine over the last 25 years I've been at Qualcomm. So a key piece of national security and is tied completely with economic security in the fact that this technology leadership and this investment in R&D, either, it'd be nice to have, additional federal dollars in R&D, but investment in companies by being able to license their technology and get a fair return on that technology is what's providing those jobs, not only in the tech sector, but in creating this whole, these whole ecosystems. If you look at you look at mobile, for example, it's the largest technology sector, I think that has ever occurred, and it's imperative for national security that we actually continue to invest in the kinds of fundamental policies around the patent system and around being able to license those technologies to be able to continue to thrive there. And of note is China in particular is very interested in and being very successful in their own patent system. I think Director Iancu cited that last year China was the second or the third in terms of the number of patents granted, and so they are putting a very strong focus on technology patents, while the American patent system that has served us so well is under attack. Mm-hmm. And I'd also comment that I believe that the number of women inventors in both China and Korea are higher than the U.S. We've got to fix that.
So one quick point for the whole panel. Please don't rely on me to ask questions. If there's anything that your fellow panelists are saying, I think the audience would much rather hear from dialogue between the four of you than me. But I do want to raise one of the issues that Sue is making, that innovation has been a comparative advantage of our economy for a long time. Whether it is reinvestment of R&D money or not, as a commercial enterprise, the incentives are make money off of your investment and your innovation and your risk-taking. But so, Kellyanne, I wanted to talk to you about the China trade deal, some of the comments that Sue was making about the challenges specifically associated with China. So I'd like to hear your perspective on how those negotiations have played out and what the response is on what pushback there is on a more rigorous environment of intellectual property. But then also, is it just China? And is this an issue that we have more broadly?
Sure. No, and thank you so much for having me here today. Thank you to Brian for organizing wherever he is as well. It's a pleasure to be up here with such distinguished panelists. You know, to answer your question, I'm actually going to go back a few years because the premise of this particular panel is quite interesting for me. I've been a trade negotiator for over a decade. I served as the president's advisor on international economic issues, both for the National Security Council as well as the National Economic Council. So to see these two worlds collide of economic security and national security is quite remarkable. And I think it plays out very poignantly in the China deal, which is really for the first time on the world stage, we're starting to see these two worlds intersect and see how they fit together. And that's not always perfectly in many examples. But, you know, as far back as 1962, Congress physically removed the trade negotiating function from the State Department and put it into the White House because they were concerned that foreign policy was getting too intermixed with economic policy. And now at this point in history, in 2020, we're actually seeing the two worlds merge back again. And we're seeing a lot of the kinks being worked out. From my perspective, it was incredibly important for us to address the challenges posed by China. From a national security perspective, obviously, innovation has a strong correlation with our ability to defend ourselves militarily and all of the national security implications there, but also economically, as Sue pointed out. I mean, 10 years ago, the top few companies that invested in the U.S. economy were companies like AT&T, Exxon, Chevron, and GE. And today, the top economies investing in the United States in terms of job creation are Amazon, Google, Microsoft, and Intel. So we really are in a world where we need to protect our innovators, where we really do have this comparative advantage. But for the last decade, we've been struggling with what to do with China's industrial policies. You know, China, through a number of steps, has decided to take on the goal of becoming independent in terms of technology and manufacturing. And so they set out in 2015, Made in China 2025, which is a strategy that by 2020, they'd be 40% independent. By 2025, 70% independent, and then dominant when it comes to high-tech manufacturing by 2049. But unfortunately, they've done this by taking a number of unfair trade actions. So issues like Rob pointed out of forced technology transfer, intellectual property theft, cyber intrusions, discrimination in terms of licensing have been the means by which they've sought to achieve those ends. And from a trade negotiating perspective, we have certain tools that we've used over the years. You know, the Obama administration certainly tried to resolve these issues through two formal dialogues. There was the JCCT and the SNED, where they discussed these issues a number of times, and China made a number of oral commitments that they would refrain from forced technology transfer as a prerequisite for market access, but yet nothing was done. The Obama administration also tried bringing WTO challenges. They brought 21, as a matter of fact, against China's state-directed economic activity, but nothing really changed. And we also tried working with allies who shared concerns. And while there are some fruit that's borne there, which we saw recently in a tripartite statement by the EU, Japan, and the US addressing state-owned enterprises and state-directed subsidies, that is a slow process, and it takes a long time to negotiate new rules. But ultimately, there were no international rules that covered a lot of what China was engaging in. So the administration launched a Section 301 investigation in August of 2017 and found that China was engaged in behavior and policies that were discriminating and unreasonable. And at that point took the step to do three things. One was to launch a WTO case where there were international laws covering the licensing practices. Two, to come up with new investment screening rules. And three, to impose tariffs. And that last piece is really what brought China to the table. And it's pretty remarkable to see a year and a half later what we've achieved in terms of a phase one China deal. I was one of the negotiators at a deputy level, so talked to my Chinese counterparts about a whole suite of issues. And if you look at the Section 301 report and the four technology transfer elements that were discussed as part of China's plan, the phase one deal reflects three of those. So three of those issues are addressed, and there's certainly more work to be done, But no administration in the past had been successful at actually getting China to the table in a meaningful way on those issues, nor had any other country. And we're now seeing other countries emboldened to engage in those discussions with China. So from an economics perspective, we're making headway. We're beginning to do what we can to protect U.S. innovation and the U.S. industry. But we're also seeing a knock-on effect of issues like export controls, investment screening, sanctions, and more national security type tools that are being added to the mix and the suite of conversations that we're having with China. So there's certainly more to come, and I think it's quite interesting to see how these worlds collide, but it is so important that we continue to protect our innovators.
So, Nadia, I want to get to you on some of the strategic issues, but Rob, I'd like to get your reaction from the perspective at State. Kellyanne talked about tariffs really bringing them to the table for the first time, and I think many of us in this room have had the experience of negotiating with the Chinese, and the realization that diplomatic efforts, no matter how vigorously pursued, the Chinese were reacting to internal incentives that any amount of diplomatic pressure or discussions were unlikely to jar loose. And I do believe, and I think it's right, that the tariff system that we put in place was the shock to the system that actually brought them to the table saying, you're actually now reaching into my domestic incentives, right? This isn't bad press for us anymore. This is potentially domestic industries that we're concerned about, that we have a strategic interest in, potentially feeling the pushback. From the perspective of State, where it's diplomacy first and we don't get to this point, how has that all been internalized? What is the reaction from our trading partners around the world? I mean, the imposition of tariffs as a tool really runs against a long-standing broad consensus of free trade and moving things forward. So I was just interested in the perspective from inside the State Department.
Yeah, thanks. That's a great insight and a very thoughtful question. So we've really shaken things up because I think for so long, the general assumption was, the conventional wisdom was that as China got to be wealthier, their population got wealthier, they would demand liberalization of their political regime and they would demand liberalization of their economy, and that just wasn't happening. And so we put new tools on the table. I think if you look at what the European Union did last March, it really shows that we've gotten huge traction. They wrote a report about China, and for the first time, they said China is a real competitor of ours, and they're doing things that are discriminatory, largely along the lines of what we said. They said it in ways that may not have the same headlines, but they certainly agreed with us on how to move forward on this. I think at State, though, we would say diplomacy first. We want to talk to people about things, but we also need to have tools with us. We think about the export control tools, the sanction tools, others that we need to use. When we see human rights violated, we've sanctioned those entities. We've sanctioned actors in the Xinjiang province in China who have been using their tools to abuse people's human rights. We've put Huawei on the restricted entities list for their activities that include criminal activity to facilitate the transfer of technology to Iran. So I think we've been clear that we know that we need to use some tools sometimes to get people's attention. I mentioned cyber-enabled intellectual property theft earlier, and that is one where we also recognize that we can call out countries, we can attribute their bad behavior, but we know we need to put additional tools on the table to change the decision-making calculus of leaders in those countries to make them not so willing to use cyber as a tool to achieve those ends that they couldn't otherwise achieve. So, we've already done sanctions, law enforcement activity. We're looking at other options that we have to cause the decision-making calculus to be altered in those governments.
So this does bring me now to Nadia and the sort of the strategic lens of the National Security Council. One of the things I think we were talking about in the back, for a long time, it was also a pretty broad bipartisan consensus that industrial policy was ineffective and caused more problems than it could address, that the government shouldn't be in the business of picking winners and losers, let market forces determine the best outcomes. And I think in a purely domestic context that makes sense, but I think we're seeing a breakdown of that assumption when you're faced with a foreign competitor that takes a very different approach. And their industrial policy doesn't just include picking winners and losers amongst their domestic participants, but really putting the thumbs on the scales in favor of their domestic industrial base vis-a-vis international competitors and companies like Qualcomm. So how should we be thinking about that in terms of, is there such a thing as, strategic planning that falls short of industrial policy, but recognizes that we've got important interests in having strategic industries not be completely eliminated by the interference of foreign actors in favor of their national champions?
Right. Sure. Thanks, John. Just an overall comment. What struck me about the panelists and what we've talked about just a few minutes ago is essentially, I think it's important, especially in this contentious political environment, that the diagnosis of the problem actually is remarkably consistent, right? And I think there's a fairly robust bipartisan consensus on the diagnosis of the problem that we've all been talking about today and earlier today. And I think that's important because then it defines what we need to focus on, which is how to address that problem set. And the how is in many ways where some of these debates are going on. It's also interesting for those who are, to Kellyanne's point about history, there's a speech that Bob Zoellick, gave, known as the Responsible Stakeholder Speech from about 15 years ago. And for those who are interested, I would suggest you go back to that. You can find it on the web because it really sets out a lot of the debates that we've been having for 15 years. And clearly what had been tried over and over and over hadn't worked. So I think it's just a nice historical starting point. To your specific question, John, I mean, clearly we're facing a problem of how we compete against a model of civil-military fusion, right? The Chinese model is one of civil-military fusion. And how does the United States, democratic, open society, compete against that model? And I think right now we're at this pivotal point where we're working through options and models to compete. I'm not going to use industrial policy because that would get me killed in some circles, but I do think that we need essentially to think about what is the right combination of government incentives. But the private sector has a role too. It's not just the government rethinking this role, right? There have been market failures, and clearly the government does need to rethink its role in many ways. And we're seeing that in many different ways, right? We're seeing consortiums of people coming together to think about investments so we don't completely lose out in 5G. We're seeing different movements. But what does the private sector need to do in this domain? What is at stake? What's the shared understanding that the private sector needs to think about as well? So I think in many of these panels we talk about what government has to do, but we need to be thinking about what the private sector and what key actors, and Qualcomm has done a very good job actually of articulating its role in this space. What about other companies? What about capital markets? What about lack of transparency on the U.S. stock exchange and companies investing in Chinese companies that aren't transparent? What about the DIU report that talked about China's use of targeted investment strategies to gain inroads in key national security technologies, right? There's a private sector role to this as well. So I think that what we're grappling with now is what are the right models. And finally, we're seeing the economy as a domain of competition in a different way as well. So in the past, we can all talk about military instruments of competition, right? Our weapon systems, defense, offense. We can talk about political competition. But in the past, economic competition has sort of been, well, what tools do we have? Sanctions? We're sort of grappling now as a country, and I think a lot of these debates over the past 2 years, put out there by the Trump administration and the national security strategy and thinking about China as what tools do we have in our economic toolkit to compete in this national security, technologically driven domain. And I think that's a ripe area as well. Both offense and defense, right? The offense is not popular to talk about. It's not just protection. There's an offensive potential element as well.
So Sue, you certainly chomping at the bit. I wanted to, before you jump in on that.
Since we brought up China and private industry, I'm just going to jump right in.
I do want to get one quick to add as in your answer. Your reaction to Attorney General Barr's suggestion that maybe the answer is for the government to invest in strategic industries directly rather than trying to do things around the margin. So I'll throw that curveball into your reaction to what Nadia had.
Okay, and we'll take that first. I think that's not a long-term solution. I don't think that's a sustainable solution. We are, Nokia and Ericsson have done a really phenomenal job at staying in a very tough industry. But I think if you want it's going to be very difficult, if not impossible, to get an American company to enter what we call the traditional cellular infrastructure market. We lost Motorola, we lost Lucent, we lost Nortel out of Canada, and so Ericsson and Nokia are our allies in this battle, and so we have to make sure that there's a role for them going forward. But we are also very interested in the notion of having, say, in 2 to 5 years, an option by disaggregating these networks and talking about virtualized networks. And there's already a number of small and large companies American companies in that space who simply need to be able to scale. They already have solutions. So I was not in total agreement with the Attorney General's comments. I do think that...
I don't think a lot of people in the administration were either, but that's a different...
But if I could just add something here. There's been a lot of good discussion around trade and the entities list and the Department of Commerce and export control. And one of the things that we are facing at the company is the unintended consequences of some of the trade actions. For example, any sort of, not any sort, but as we get closer and closer to decoupling kinds of conversations with China, I think the government has to realize that to a large extent, China funds, in many sectors, China actually funds U.S. companies' R&D. Most U.S. companies have a significant portion, including us, of our revenue come from China markets. And so anything that significantly blocks China markets has a consequence, a very real financial consequence on American companies. And I think you also want, in the long term, you want to make sure that China uses American technology as their basis rather than the alternative, which is the U.S. and rest of the world using Chinese technology. And one of those unintended consequences that we're seeing right now is with Huawei and the 28 other companies on the entities list, which is good. We're not arguing against that. But in the standards organizations, and Rob alluded to standards being a key part of leadership, we're seeing a dynamic where, for fear of running afoul of export control laws, rules, our engineers and going to these standards meetings are reluctant to participate fully in those standards meetings, which in the long term has the effect of blocking U.S. companies, exactly the opposite of what was intended, blocking U.S. companies from participating in the standards. And so we are seeking clarification from export control in the form of an advisory opinion on, what can we do in these discussions, in these standards meetings. But I think that's just an example of these issues are very subtle, and so we don't want the cure to actually be worse than the disease.
Well, usually, to your point, anytime the government gets heavily involved in something, there are often many unintended consequences, right? So that's the wariness. But not to put Rob and Kellyanne on the spot, but what is your sense of where the government is on the issue that Susie's brought up? Because as I was reading about it, it did strike me. I felt that when I left the NSC, there was a great appreciation for the importance of the U.S. being at the standards table, being at those bodies, making and shaping those standards. So I would think that it would very much be an unintended consequence, and that people are working to rectify this.
Yeah, so what I understand is that last August, when they renewed the temporary general license for Huawei, there was some guidance put out specifically on this issue from the Commerce Department, and I don't know where it stands there, the Secretariat for the Export Control Board, effectively, so I don't know where it all ended up. In our view, of course, we want to see American companies leading these standards bodies, having important roles and able to engage fully. Every day at the State Department, we're helping organize our involvement in multi multilateral, which is government-dominated stakeholder standards development bodies like the ITU, the International Telecom Union. We're also working with NIST and others in government to make sure that we're fully engaged in 3GPP and other standards bodies so that the Qualcomms and others are succeeding there. We're trying to address issues that we've also seen out there, which is that there's been some voting that's occurred in some of those bodies that's not based on what is the merits of the individual who will lead the group, but there's a national flag thrown by the Chinese government to get their companies to vote for a particular individual that the Chinese government, that is a Chinese national, to run a certain organization. So we're trying to address those every day.
Mm-hmm. And just to add on to your point about unintended consequences, because I think it is a good one, and most of the companies around the room or stakeholders are the ones who are feeling the unintended consequences of a lot of the actions that we're taking. You know, it's an imperfect solution for a challenging problem. You can't fight unfair trade with free trade. You can't say we're just going to continue to liberalize, we're going to continue to tear down barriers, when you have another actor who is a very strong actor and an aggressive actor who's engaging in things that continues to not only hurt our economic interests but our national security interests. And so in terms of coming up with the tools we have the traditional tools. We dusted off Section 301 as a new tool, which we've used towards China. We've also used it towards France, to answer your other question about other actors besides China who are engaged in discriminatory behavior. But it's going to take a constant conversation between multiple entities, including the government, stakeholders, NGOs, thought leaders. I mean, we are all in this together, and we're trying to come up with a solution that makes us better off. I mean, free trade is ultimately a prisoner's dilemma. When everybody plays by the rules, everybody wins. But when you have an incentive to cheat, it throws the entire system off. And we're in that position right now. So how do we as a community, not just the United States, but our allies and our companies come together and create a better trading system and a better world that addresses the modern challenges and frankly keeps us all safe?
We frame a lot of this a lot of what we've been talking about around the specifics of 5G. Because the alternative to unintended consequences are intended consequences. And we're dealing with the results of a very intended consequence of strategic decisions by the Chinese. We are going to dominate this technology. We're going to do it through direct subsidies into companies. We're going to do it through, if not turning a blind eye in some instances, supporting intellectual property theft. The companies that you talked about, Huawei, there's lots of dispute about precisely what sort of a direct threat they have, but there's been legal cases made that some of the foundations of that company was based upon the misappropriation of intellectual property. And when you said, unfair trade, you can't battle with fair trade. When you're looking at the possibility that based on their intention, whether it's through China 2025 or just supporting strategic industries, that the Western counterparties just fail. And we reach a place where critical strategic supply chain items are sole sourced from a particular country or a particular region of the world. So it's a long way of diagnosing the problem. What are the things that we can do from Qualcomm's perspective, short of taking direct foreign investment, short of having our side engage in the exact same behavior as the other side? Are there a list of things that, in what Kellyanne was talking about, some of the things that Rob has talked about, that you see as the most successful path to counter some of these aggressive state actions where, like I said, they very much have intended consequences that they're pursuing, and how do we keep them from reaching their aims?
For me, I'll cite two fairly different ones. Bringing it back to sort of the patent discussion, there's multiple kinds of IP theft, and we worry about them all. And we are very thankful that the U.S. government and the administration is so concerned about intellectual property theft. One form of intellectual property theft that sometimes people don't think about is patents are inherently public. And so one form of patent theft or intellectual property theft is for companies elsewhere in the world, which happens, and it has happened to us, using your patents without paying for them, without paying the license fees for them. And I think that's an area that it'd be interesting to see if we could get some additional enforcement attention on. I am not a patent attorney. I'm an engineer, and I'm not a policy person either. And I think the second brings it back a little bit more to virtualized networks. We started looking at this path from a policy point of view. We do, chipsets for small cells, and we do a lot of the fundamental technology. But we started looking at virtualized networks or disaggregated networks where you can, instead of having, traditional big black box cellular infrastructure, you break it apart and you have it creates competition. You have new companies come in, potentially companies with strength in software where the U.S. is currently excelling. And so that is our view for one of the promising technologies that would maybe give us some choices in 5 years. My problem statement is always Ericsson and Nokia are wonderful partners and do really good work, but Huawei has taken all the profits out of that sector, and so they're struggling to compete with Huawei, and so I'd like to have something forward-looking that we could that broadens this market. 2 companies or 3 companies does not really make a market for cellular technology, and so that's one reason that we're looking at this virtualized networks or this disaggregated networks.
So I'd like to get back to that, and Rob, you've got something, but I wanted to get to the point you made about companies just misappropriating intellectual property without paying for it. So it's not a cyber extrusion. They just know what the technology is and they build it into their product. It's a lot less transparent. We were talking in the margins outside. A lot less transparent than a physical good and intellectual property theft in terms of brands and things like that, where you can go and identify a product that's not being paid for. Are there tools that can be provided? Is there a better legal regulatory scheme so that when the buyers of equipment have more visibility into whether or not the components inside that equipment, there could be Qualcomm intellectual property deep inside a piece of switching equipment, deep inside a back office router, something else, where even as the buyer, it's not going to be transparent to them, what all is inside. Is there any sort of, better legal regime to verify what goes into a product before it comes into the supply chain?
I'll let someone else answer that because I'm not the IP lawyer, legal expert.
Well, does that work for 301? Are there kinds of things that you could bring in to say, how do we get deeper into the supply chain so we can make sure that intellectual property is being appropriately accounted for?
Sure. I mean, I'm also not an intellectual property lawyer. I'm a trade one. But there are certainly steps that you can take, right? I mean, there are ways to trace back to a supply chain and require that kind of reporting when it comes into the country or into a market. The problem is there's always a balance between a regulatory burden versus allowing trade to continue to flow. So there will be consequences for that kind of system. Maybe ultimately it's something that countries should seek to adopt to try to get greater visibility and transparency, but you're going to have to weigh the suite of issues before you adopt a specific regulatory regime. But ultimately, we talked earlier about standard-setting organizations or international organizations that follow trade, follow IP, and all of these suite of issues. And I think it's important that countries who are trading together all have a seat at the table and can discuss those types of issues together and come up with an appropriate solution.
Nadia, you have some thoughts on that?
Well, there might be. I'm neither an attorney nor an expert on supply chain issues, but looking at sort of the revolutionary thinking about supply chain issues has been quite interesting over the past 2 years as well. We're seeing DoD take a very different and more serious approach toward it, but looking at what technology can do to help solve some of those problems. So I think there are ways, and it's controversial, but adherents to blockchain have argued that blockchain can be used effectively to help. So I think there are ways that actually technology could address some of the concerns that you mentioned.
Well, I think it's my role as a moderator to ask at least one question of every panel that is completely beyond everybody's area of expertise. So I've got that out of the way. But Rob, you had thoughts on on Sue's earlier.
First of all, I want to agree very much. I think there's huge promise in the open architecture for 5G, that we can see more competitors in that field, that we can see playing the strengths of U.S. innovation in the area of software, more of white box solutions. I think there's great promise, and that's an area where there needs to be public-private partnership on solving the problems of getting not just the concept in the lab to work, but getting it field deployable. But on the point of how we address sort of unfair competitors like Huawei, I think one thing is we've been on a global campaign that many of you have been reading about in the press, which is to make sure we're talking with our partners so they fully understand about technology companies like Huawei and their inability to resist any command of the Chinese Communist Party. When you don't have an independent judiciary or rule of law, any dictates by the executive branch go straight through to the companies. They really don't have private companies anyway in China. They are totally at their beck and calls. That means that all of our partners who care about privacy, care about their protection of their data, are potentially putting all of that at risk to the Chinese Communist Party. Basically, they have a front door access. We know how much effort they go through to steal from Equifax, to steal from a number of other major breaches that happen in the United States, as well as the Cloud Hopper attacks. If they have front door access through Huawei, it'll be that much easier to get all of their intellectual property. So I think as people around the world understand this, they're going to say, wait, I do have concerns about this very sensitive technology being in the hands of the Chinese Communist Party. So I think that's shaping the field somewhat. But on the pure economic front, I mean, we realize that China is a closed market, so they say how much can go to any Western competitors of Huawei and ZTE within the Chinese telecom market. They then use the sort of subsidized internal market to lower the rates around the world. And we know that the one thing you did mention was that the subsidy that comes from financing the Chinese Development Bank, Chinese Export-Import Bank, that they then give to Huawei. So they help them bank a deal, but they'll offer 0% interest for 20 years, which is not something that's available to Ericsson and Nokia and Samsung as they're seeking to get deals with these operators. So we make sure that we point that out. We in the United States have the Export-Import Bank and the reformed OPIC, which is now the Development Finance Corporation, that can put money into helping finance deals around the world. So there'll be competitors for a free and open system of communications technology. And there is some burden, I think, on the Europeans, too, to recognize that the European Investment Bank still finances Huawei within Europe, which they have two good European vendors there in a Swedish company and a Finnish company, yet at the same time they're using their money in the European Investment Bank to finance the Chinese unfair competitor, I think, by anybody's definition of how they're competing. So I think there's a number of steps we need to do both on the security side and the economic side to make sure that we're formulating policies and educating the public about what's at risk here.
So I'd like to get all of your collective views on this, and I'll try not to stump you like I did the last time. But we've talked a lot about unintended consequences. We've talked about the affirmative things that other countries do to support their national champions, and we know some of the things that we don't want to do. What are the things the government can do within the sort of construct of free market and innovation that we've been talking about that is productive? One of the things that we've talked about that gets brought up a lot is more research and development funding, either directly or indirectly. One of the challenges I always had as a policymaker when people came in for research funding, kind of development funding, right? It's hard for a private actor to say, we're going to invest money in research, which by definition doesn't have a commercial path that you can predict. But are there creative things that we can do around the margins that fall short of the kind of clumsy industrial policy and taking investment in companies that does enhance the incentives for innovation and the creation of new intellectual property? Sue, if you have some ideas, but I'd like to hear from everybody if there's any thoughts.
My ideas are very simple, and it's support this system, this patent system, the American intellectual property system. Qualcomm doesn't ask for handouts or R&D funding from the government. What we request is policies that support the intellectual property system, that support our ability to obtain R&D funding, that support the talent generation, that support university research. We get a lot of our people from universities, and we also, have technology transfer programs as well. So, it's not as immediate as a policy that, puts a certain amount of money in somebody's pocket today, but it cannot be underestimated how important that intellectual property system has been to the U.S. and to companies like Qualcomm, and will continue to be if we don't blow it.
I mean, I think that there are a bunch of areas. One, to continue what I think the administration has done a good job at reducing regulations, right? Speed is critical in this whole domain. Speed and agility are often undervalued dimensions of power. When we talk about power, we talk about economic power, military power. Speed matters, and we see that today. So the government can get out of the way in key areas or ensure that when unintended consequences exist, to your point, Susie, do something about it, right? Don't just, let this indecision rest for months and months and months. The government can do better. Second, the government can take more risk in certain areas in terms of R&D, shift its mentality and allow itself to take more risks, which means sometimes you'll lose, but sometimes you'll win too. And think about models where you get some of the winnings as well. Why does government always on the back end take the losses but not the profits, right? Third, there's a test bed issue, which I've become more and more interested in. So I just had the opportunity to go to the Department of Energy labs, which are really extraordinary. And the amount of expensive infrastructure for testing is extraordinary. These labs can and are being used as test beds. They offer opportunities for companies to come in and experiment and use those facilities. DoD, too, is actually willing often to do that, right? There's a really innovative, I forget his title now, but Will Roper, who many of you know, really open to the idea of getting companies in to use the facilities to test, so that's an example of, that's not an industrial policy, but that's a capability the U.S. government has built up. Making the private sector, making it open to the private sector is a specific way that we can, the government can help in key areas. To get more companies out there, Susie, pour your point to make sure that it's a competitive marketplace.
I want to hear from the rest, but is there anything about the transfer of intellectual property between the government and private industry when they partner in those sorts of things? Is that a system that's working well? Is that something that you found is beneficial?
It came up during the tours of the labs, and they have mechanisms for either, if it's protected IP, then the labs are required to protect it, but often companies will come in and be willing to share that IP, and then that benefits the broader range of researchers at the labs as well. So there are mechanisms to do one or the other. Susie probably knows more than I do about that, because you've probably been to those labs much more than I have.
I want a tour of the DOE lab. I haven't been.
Oh.
But Kellyanne, what's your thoughts on Sue's comments of, protect the system we have, and are there things that we can be doing better to make sure that the system we have is reflected and honored in other places?
Yeah, I think it's a combination of what Susie and Nadia said in terms of what we can do here at home domestically, as well as what we're doing internationally, right? I mean, otherwise we're just going to be back in the same situation we were at if we have, the most innovative tax policy, the deregulatory agenda, we have pro-investment policies, but then we can't export what we do, or it gets stolen by other countries, or there are regulatory barriers in other markets that prevent us from actually exporting any of our innovation. It's going to stifle our ability to continue to grow here. So from an external and international facing perspective, I think we just have to keep doing what we're doing with close consultation with stakeholders in industry, of going hard after those who steal our intellectual property and working with those who want to work with us. Because ultimately, pro-investment policy, not just here in the United States, but internationally and adopted in other countries, will be good for them too. And so that's what we'd like to get to. But I think I really enjoyed hearing some of the ideas about the domestic steps we can take too, whether it's research and development. The president's budget just came out. I think he doubled the investment for AI, or workforce training programs, or whatever else we need to do. But I think you need both sides of that coin to make it work.
So I think we're running up on time. I want to make sure when we have an actual real live actual government official rather than a bunch of former government officials, give Rob a chance to sort of, sum up some of your thoughts, and then if we have a moment or two, we can go to some Q&A.
Great. I would just follow on to the question you just asked and say that, I'm out there all the time traveling to see counterparts in governments in Europe and Japan and Israel and places around the world. The coordination that we can have to see our collective like-minded policy goals achieved is an important agenda item for us everywhere we go. And we're not going to design exactly how companies are going to work with one another and with academic institutions, but we can at least make it provide a format for them to get to know one another and make the connections. I think very importantly, along with having a strong patent regime that's the envy of the world, is to also have the right kind of regulatory environment, which others have mentioned. And I think particularly as it relates to the access to data, for all future digital technologies, data is so important. Data is what you need to train AI algorithms. And so having the right kind of data policies that are not going to act as a wet blanket on innovation is really important for us to focus on. And the guidance that the administration released just a couple weeks ago on AI regulatory policy, saying that needs to be a very strict cost-benefit analysis applied, and you think carefully about alternatives such as standards or guidelines that can be used in lieu of having actual regulation, legal regulation. So I think we need to be very careful about how we preserve the United States as a place for innovation in these fields.
So I think we've got a moment or two for maybe a question or two. Sir, I think there's a mic moving around.
Thanks. So we were talking earlier a little bit about 5G as a major concern and how Huawei is an actor and there's concerns about that. The U.S. Patent and Trademark Office, someone recently did a landscape study of all the 5G patents that will cover and be the equivalent of licensing for all of 5G. And Huawei has the most out of any applicant. The top 9 applicants, only one, Qualcomm, was an American company. Of the Qualcomm applications, only about 500 have been granted. There's another 1,500 or so that are still pending at the U.S. Patent and Trademark Office. The U.S. Patent and Trademark Office has the ability to not grant patents based on national security concerns. And I'm wondering if anyone has given any thought to stepping into what is certainly going to be the future of 5G licensing and trying to prevent the outflow of licensing revenues using U.S. patents to do it to Huawei or other state actors.
So I don't work for the Patent and Trade Office. First of all, patent counting is a little bit of a slippery slope. It's kind of like counting contributions in a standards organization. There's different quality of patents. So I think there was a media article a number of months ago who cited that also Huawei has more patents than U.S. companies do. So we sort of take that with a grain of salt. We are. If you look at the people Huawei is certainly very competent, and they submit good patents. In terms of the policy of stepping in from a national security point of view, that's actually the first time I've heard that or thought about that. I would be very careful that does not have unintended consequences. I'm not a policy person, and I'm not an IP lawyer. But to an engineer, that seems like it's starting to kind of game the system. So I would not be in favor of stepping in on the granting of patents based on sort of who's ahead in these critical sectors, because I'm not sure you can draw a direct line to national security.
Of proactively doing things that would help the deployment of 5G. I think we all know that the telcos are heavily indebted, and after we auction off more spectrum, they're going to be more heavily indebted. Is there anything we can do in terms of spectrum policy to sort of accelerate the process of of more rapid deployment, first mover deployment of 5G systems. And specifically for Susie, your idea of virtual networks, is there anything in the realm of spectrum policy that would help advance the testing and scalability of that project?
I think the more spectrum, the better. You know, there's always this argument in the U.S. about millimeter wave versus C-band and some of these other spectrum bands that are not necessarily up for auction. I think spectrum is the lifeblood of any cellular system. So you've got to have the equipment and you've got to have the spectrum. So anything that makes spectrum easier to obtain by U.S. companies, especially ones you can imagine policies that make spectrum easier to maintain or to acquire for incentivizing the deployment of virtualized networks, for example. That would be an interesting policy that would probably help virtualized networks actually scale. In terms of specific, you know, which band and who should get what, I probably shouldn't delve into that.
If I may just add, yeah. So, by the way, congrats on your op-ed in the Wall Street Journal. I enjoyed reading it. You know, but one thing we've done though is we've really increased the supply. So you increase the supply, you can reduce the cost. If you know, so you know, in just last week, you know, the FCC announced, Chairman Pai announced that they've had a new path forward on the C-band, which is mid-band spectrum. We need more of, and that's definitely going to be something that'll probably reduce the overall cost to have adequate amount of spectrum in the mid-band range. So a lot to push the supply out there, but there is a lot of debate about should there be around the world and in different regulators where they're much more cash constrained because they don't have access to the deep capital markets that our major companies have in the United States. And it is very positive, of course, to see now that T-Mobile and Sprint are going to have their merger cleared, or so it appears from the press. That will allow them also access to the capital markets they'll need to deploy a 5G network.
Spectrum, while expensive in the auctions, is a small part of the overall capex that goes into a wireless network, but I think Rob is failing to take credit for the hard work the State Department does going to the ITU, going to the World Radio Conference, and making sure that we've got a spectrum regime that's reflected around the world that is making spectrum available for innovation and making sure that we've got harmonized markets so that innovators like Qualcomm can build once and sell everywhere.
But the timeline is an issue, right? I mean, in terms of panelists, right? The time it takes to free spectrum and the timeline of auctions is a big problem. And that's an example, too, of can government do better? Can we relook at how those auctions are done, given the imperatives of what we face today, different than 10 years ago? Taking 4 to 5 years is a long time, actually, in the competition we're in right now. And that's of concern, and that seems to be something we could probably work harder on.
That's a good point. I do think that ties in the standard setting. So long as there is some spectrum visibility that the standards bodies can get around, they can start adopting band plans and assigning frequency bands for different technologies. So long as everything is lined up and we're not getting bottlenecks, I think that's the important thing. We got 2 over here.
Bill Wichterman. Susie, you and I were talking earlier, and I wonder if I could prompt you to say about engineers and talent coming to the U.S. from other countries versus going to other places.
Sure. You're a good plant, Bill. So Bill and I were talking about my observation, because I think I'm very involved in our STEM programs, and I think a lot about STEM diversity and talent acquisition and people who actually drive these kinds of technologies. And my point was probably at least in the last 40 years in the whole technology area, the U.S. has benefited tremendously from the brain drain ending here in the U.S. We have been able to attract not just to universities, to learn this technology, and there's a lot of discussion about people taking it back, but attract people who work for American companies, who do these innovations, who become citizens, who file patents on their behalf, and really helped largely drive the whole technology innovation in the last 40 years. And my other observation is that is not necessarily a given going forward. Both India and China now have very significant interesting companies that are attracting a lot of worldwide talent to join them. For both, you can make a good living at it, and you can also do very interesting work. I think specifically in the AI area, the word, amongst my AI colleagues is, if you want to do really interesting R&D in AI, China has the companies. And so I think it's a telling point that we are competing for worldwide. We, the U.S., are competing not just for U.S. talent, but for worldwide talent. And being able to fund the universities, being able to have the companies that hire these people is a key part of actually attracting that talent to come here and stay here in the U.S. And for our own people, I'm sure there's technology people who were born and raised in this kind of system who find very interesting jobs elsewhere as well. You have to, engineers follow the interesting work. Put it that way.
We've got one last question.
Thanks so much. You guys have talked about how tariffs were effective but have unintended consequences. Do you think when we approach phase 2 negotiations, are there alternatives that might have less unintended consequences?
Kellyanne? Sure. Happy to take it. Tariffs were what proved effective, right? As I spelled out at the beginning, there were 3 actions that were taken. One was a WTO case, another was new rules on investment screening, but the third was really what got China to the table, and it was the tariffs in the first place. Now, bear in mind, we still have a number of tariffs that are still there. The December 15th tariffs did not go into effect as a result of the phase 1 deal, and then the tariffs that had been imposed earlier in the fall were brought down to 7.5%. But there are still hundreds of billions of dollars worth of tariffs left, which should incentivize further progress on a phase 2 deal. But ultimately, it will be up to the U.S. and China as to whether that gets done. And in China, there are different voices on different sides of the table, much like in the U.S. There are the hawks, and there are those who want to continue to do business with the U.S. And so it will be decided by politics. But I think tariffs have proven effective, and that's why they've been used. But certainly, there are all sorts of tools that are being considered and discussed.
Great. Well, I think that's it. We're getting the time call. We join me in thanking our excellent panel.